May pleasure lordships, item number 4 lordship. The order this petition lordship, my representation already disposed of compliant.
Huh?
My representation disposed of lordship.
What do you want?
The lordship, the order this petition lordship.
And amid the learned counsel appearing on behalf of the petitioner, he wants to withdraw the instrument. If the petitioner gets instructions to withdraw the information. Accordingly, the petition stands closed on withdrawal. Here on behalf of
Reply of lordship.
So I mentioned item number 31, my lord. In this case, we will be filing our affidavit in office during the course of the day. So I have taken consent from the petitioner side after it may come up after 2 weeks. My lord.
make the mention when the matter is there.
May please the lordship, my lord. My lord, this motion matter yesterday we filed, my lord, may come up on Friday, my lord. Obliged. Maybe the lordship, I beg to mention for listing the item. The matter has been fixed for after 2 weeks. This matter relates to contextual bills, your lordship. And there is an emergency on the point of that GST will be, is the last date of November last. I have
You
already given representations.
You are for the,
Petition, your lordship.
you want
Contextual
it
matter.
for? You have an I.
Writ petition, your lordship. Writ petition I have. The court has, this honorable court has directed to matter list after 2 weeks, but the matter has not been listed. I have already approached for the registry. Your
Next Monday.
lordship.
Next Monday.
Please, your lordship. Lordship, with the consent of others, sir, I like to mention item 30, lordship.
Item number
30.
33.
We taken up,
Yeah, when do you want it? 33.
30.
Okay. At the request of the learned counsel for the petitioner, matters may be adjourned to be listed after 4 weeks.
Obliged.
Like to mention item number 55. lordship. Yesterday we filed our affidavit. Lordship, can you call for the affidavit? It's not in the report.
May I please, your lordship, I beg to mention item number 23, lordship. I have
20?
lordship. I have taken consent from the other side, lordship. Lordship, in this matter, 3 petitioners have already been expired. And we need to file implement petition, lordship. So matter may come up after 3 weeks.
Who died?
Lordship, petitioner number 1, 3, and 4.
And matter pertains to what?
Lordship.
Matter pertains to what?
Matter relates to lordship. They are the owner of a land and their land is illegally occupied by the railway, lordship.
Eviction,
Not eviction, lordship. They have
public
occupied.
premises.
They have occupied, lordship.
May I please, your lordship, lordship, with the consent of the other
Item
side.
number 23 to be listed on 25/11/2024.
May it please, your lordship, lordship, with the consent of the other side, I beg to mention item number 28.
Yes.
The conducting counsel, Mr. K.P. Pathak is unavailable.
Who?
Mr. K.P. Pathak, your lordship.
But for the respondent,
Yes, your lordship. Respondent number 2 and 3, your lordship.
matter pertains to?
Lordship, the matter pertains to charging of excess amount as bills, electricity bills.
Petitioner has no objection.
Yes, I've obtained the consent, lordship. I've obtained the consent, lordship.
To 20,
Lordship, 27th if possible.
27. 27.
Yes, your lordship.
Okay, to be listed after 4 weeks.
May I please, your lordship. Lordship, I pray for listing of an interlocutory application tomorrow, balance.
Interlocutory application for what?
For stay of a notification issued by EPGCL, my lords. A repetition is already pending for the honorable court.
Okay, next Monday.
Monday, I'm so sorry, I'm not available, my lords. It's a short matter, my lords. It's just that we are being asked to vacate the quarters of the EPGCL while the repetition is pending and we are the contractual worker working for 30 years at EPGCL.
You're still working.
But actually, because of the,
Are you still working?
no, my lords, we have been terminated because of the inaction of the EPGCL. But however, my lords, the new private contractor gave a clause due to which, my lords, we protested against. And thereafter, we filed a writ petition. And thereafter, my lords, their affidavit is also on record where they are not going into the employment agreement that is given by the new contractor.
No, you have been terminated, so how
But-
can you remain?
Despite that, the new contractor asked us to give for the interview, and my lord, we accordingly appeared.
2nd of December,
I'm so sorry, then Monday.
end of December.
Well, it will be a great difficulty because my lord, children are starting at school. my
Mr.
lord.
Counsel, if these type of matters come before me, my only thing is that I'll dismiss the writ petition. I'm giving you a chance. I am not there from 2nd of December. So 2nd of December is a better date. If it comes before you are terminated, matter over, you have no business to stay in the quarter. And there's no second option. But there are very kind judges, unlike me, who may consider your prayer.
No, no, we'll respect the judgment.
2nd of December.
May I please, Your Lordship?
Lord, I have come up with a prayer for listing a contempt matter.
Contempt,
Contempt matter.
why?
My lord,
What is
the
the
matter
urgency?
was last posted on 15/7/24, notice issued and respondents have joined by lot and thereafter have not been listed by lot.
The 29th.
Obligement.
Next, Mr. Lordship. Item 15, my lord, motion. I may be allowed to withdraw it.
Mr. H.K. Monto, the learned counsel, on behalf of the petitioner, submits that he has instructions to withdraw the writ.
However, some liberty may be given.
What?
However, some liberty may be given.
What liberty?
In case some development is there.
What liberty? Liberty is a different rate.
Lord,
There's
my
no
lord.
liberty business.
Fine.
You want to withdraw, and
Please.
with liberty, I have to hear the
Yes.
Fishery Department.
My lord,
Liberty, no liberty.
as your lordship please.
No, I'm not there. If you want, I have to hear the Fishery
Yes.
Department if you want liberty. What do you want? Withdraw? Or should we hear the Fishery Department?
My lord, let the matter,
Let the matter remain.
please.
Lordship, I pray for listing of the matter that written statement related matter that frankly your lordship has fixed it on at 2 p.m. once, but then to your lordship, yesterday also the matter was listed, but it didn't reach your lordship. So if it can come, your lordship, because the next day before the trial court is on 25th of November, your lordship.
Which matter?
Your lordship, he failed to file a written statement in the trial court,
Within time.
lordship, yes.
Yeah, that matter came up on that day, on Thursday,
At 2 p.m. your lordship.
2 p.m. But I fixed it this week only.
Yes, yesterday it again came, but it didn't reach your lordship.
Oh, it was there, na? Okay, we have it day after. 21st?
Right.
Tomorrow.
Okay. Lordship, with regard to item number 40, your lordship, I was supposed to file affidavit in reply, but I'm short of some documents, your lordship. Your lordship, can it come after? I may be given.
Mention those items when the matter is.
Supplementary item 65 for withdrawal.
Yes, Your Lordship.
Yes, you want to withdraw. Why?
With the liberty to file fresh. Lordship.
Why liberty? Liberty is the most
No,
important.
Lordship, there is a record, Lordship, because Lordship, some party have to add, Lordship, and some.
No
benefits to be
liberty
inserted.
business. There's no liberty. What is your case?
So the Lordship, our part of procedure was initiated, Lordship. In the meantime, Lordship, the respondent, Lordship, issued an communication, Lordship, had some restriction was given, Lordship. And that I, Lordship, sought for to relaxation of that communication, Lordship. But actually, in that case, the party, Lordship, the hospital authority will be party, Lordship. There is page, Lordship, 217. Some restriction was imposed, Lordship. And the hospital authority was not met party, Lordship. Subsequently, I filed an IA, Lordship, but it was become a mixed up, Lordship. Some implement, again amendment, Lordship. That's why again I would not file fresh, Lordship.
What has happened to your applications?
Application, Lordship, there is a pending, Lordship. Now nothing has done, Lordship.
And you have come only on the basis of apprehension because nearby people have been evicted.
But now actually our prayer is to get partner, Lordship. Partner procedure is Lordship at the final stage, Lordship.
And
Now the authority, Lordship, given some restriction, Lordship. Now says that the legal year certificate should be given, Lordship. So legal year certificate, Lordship, again we have applied. But that is pending before the hospital authority lordship.
Then
Lordship, in this writ petition lordship, we could not met the party lordship, hospital authority lordship.
whom?
The hospital authority, the issue is pending lordship regarding illegal certificate lordship. So unless lordship, they are implemented lordship, lordship direction cannot give into that, they may be issue the certificate lordship. Again, only for the lordship, our case, part is pending lordship. And then government also not that actually the part in this lordship upon them lordship, they are pending the issue lordship regarding issuing legal certificate. Again, lordship we are not getting the part of lordship in the absence of the certificate. Again, some problem, some documents lordship, we have to add lordship at that time with us lordship, and that we got lordship later on. Again, some other.
But how can your recommendation have any value? You can't be granted a patta because these are PGR lands.
But the lordship, that is officially can do lordship.
Huh? How? Yes, revenue. No revenue.
And now lordship, we are lordship applying.
Let I allow this thing to remain pending. Something may happen. Government one fine day may come up with a cabinet decision that we will give the PGR lands. But otherwise, except Act number 21, all are PGR lands. Question of settlement does not arise. In spite of the land advisory committee saying anything, the entire case has gone. And that too, out of 250 bighas, only 6 bighas is the question. What do you mean?
Or so far our estimate is
Chalo,
not
we
legal land.
dismiss your petition.
It is not legal land.
Why do you have to withdraw? We
Lordship.
dismiss your petition even.
Lordship.
No
Now,
case.
lordship, because we are
The
also-
entire case is based upon that land advisory committee's resolution. The land advisory committee resolution would not give any right.
Later on, lordship, circular officer also
You
include
cannot
the
get,
matter, lordship.
you file applications for some other area, not there.
No,
This land advisory, the entire land advisory committee's resolution has gone for a 6. They have given in respect to PGR lands.
No, sir, our instruction is not PGR land, lordship.
The government says by filing an affidavit, you have not filed any reply to that.
Yes, lordship. They are
Affidavit was filed in the year
going to find
2022.
reply, lordship, but it's in the meantime.
Yes, yes, Mr. Bhattacharjee, come here. In this item, he wants to withdraw with liberty. You must be very happy. But that is not the question. The question is this. These were lands, his entire claim is based upon a land advisory committee's report saying that they should be granted a settlement. There are various DAs. The total land is 250 bighas, of which 6 bighas is only outside PGR. All others are PGR lands. So under such circumstances, the affidavit filed by the respondent number 2 says that except 21, there can be question of no settlement be given in respect to the other lands. So the land advisory committee settlement has gone for a 6. This cannot happen anything. So now he wants to withdraw with liberty to again file. Should I allow it? Tell me.
So that cannot be.
He objects, no liberty.
No, lordship, liberty, lordship, otherwise,
No
lordship,
liberty.
circular officer, model report, lordship, that may be seen, lordship, page 195, lordship, will go there, lordship.
Now you
Model
mean,
says, lordship,
you,
where land
if
is
you are
illegal,
are you indigenous people?
Yes.
You are indigenous. So you can very well apply for any land and the government will grant you the lands. That is a different thing, but not in respect to these lands. Not
Yeah.
as per the, what is your prayer?
Well, period
Your prayer is
yes,
direct so and so to give patal to in the dark number 21, 24, 33 of village so and so. This can't be done.
Lordship, now lordship, we are also eligible to lordship apply before the, yes, sorry,
Why you are not eligible? You have not, you are no longer, you have other lands.
no, we have no other lands, lordship.
Have you become a citizen of any other country? Are you a citizen of, are you an indigenous of Assam?
Yes, Lordship.
Then why you cannot? Obviously not in that land. So keep quiet and remain. You have no interim order also in your protection.
That is,
Then-
they put it there, Lordship, but our basic period, Lordship, to get patta. And
You will get the patta only, but you cannot be granted. These directions can't be granted. The only direction that can be granted is to the effect that your case may be considered for in some other land. That's all, but
yes,
not in
no,
that.
here,
land.
in this case also, Lordship, circle officer says our land is eligible for patta, Lordship. That is in.
That he said, but whatever the circle
only
officer
found
says that
issues
there
pending,
is
Lordship,
not the
regarding,
gospel
Lordship,
truth.
Submission of legal certificate, Lordship. And that certificate, Lordship, we have applied, Lordship, but that is not issued by the authority, Lordship.
The Assistant Commissioner Dorong categorically says that these lands except Dag number 21 is what do you call PGR lands.
It is just, we have, if Lordship will go to contract, Lordship, we have to apply, Lordship. Actually, that is not correct, Lordship.
So therefore, you need to either refute this allegation by filing a reply that no, this is not there on the basis of these are the records, it can't be a PGR. Or there's nothing else. But you can't withdraw and you can't give you a liberty to again file it. It is amounts to bench hunting. What do you want?
Then it will be pending, Lordship, I file reply, Lordship.
Fantastic. Fairs Hawk, the learned counsel appearing on behalf of the petitioner submits that though the petitioners have advised him to withdraw with liberty, taking into account the allegations made in the affidavit in opposition to the effect that except tag number 21, all other lands are PGR lands. The petitioner would be well advised, is required, the petitioner would like to file, make necessary inquiries and file and reply. This is the matter of the 4 weeks.
Follow.
For motion item 1,
Legal Lordship. That the parties to the non-payment of contractual bill, madam. Lordship, there is the earlier order.
Senior 76.
I am not filing affidavit. Issue notice making it returnable on 8th of January 2025. The RK Musari, RK or RS?
RK.
RK Musari appears on behalf of respondent number 2, 3, 4, 5, 6, 7. Mr. Pinack appears on behalf of the respondent number 1. Two botlight you, huh? Pinack, then who's taking into account that all the respondents are duly represented, extra copies of the petition be served upon them within 3 days. The claim of the petitioner herein is that the petitioner is entitled to an amount of rupees. How much?
49 lakhs 84,572.
49 lakhs, 44,000,
84,000.
84,572. However, the said amount have not been paid. Full stop. Respondents
This is the second time I appeared before this court, my lord.
are directed to bring on record their stand by filing an affidavit on or before the next stage.
item 2,
What is this?
The legal Millard D has been put English my name Millard, but there is no any D case Millard, FT case is not there. And I have filed an application and the respondent Millard, their SP border Millard issued a letter to the higher authorities. Millard, kindly see Millard page 22. But D has put English my name.
Notice making it returnable on 9th of December 2024. Defiant appears on behalf of the respondent numbers. Two.
2 and 4, madam.
Two
I'm
and
appearing for 2 and 4.
four.
madam.
Huh?
2 and 4.
Two and four. And who appears for the district commissioner? UDAS.
Commissioner.
UDAS appears on behalf of the district
UDAS.
commissioner union. And Ms. P. Bolwa appears on behalf of the respondent number
Five.
5, 6, and 7. 5 and 7.
Yes, 5 and 7.
Who appears for NRC?
I not see my lot. I will appear.
He appears, so it goes with 6 too. And union? No union. As the respondents number 2 to 7 are duly represented, extra copies of the petition be served upon them during the course of the day. As regards the respondent number 1, the petitioner is granted the liberty to is directed to serve an extra copy of the writ petition upon Mr. R.K. Dev Chaudhary, the learned Deputy Solicitor General of India. His name may be shown in the cause list. The registry shall indicate his name in the cause list. During the course of the day. Right? The case of the petitioner herein is that the petitioner is a Indian citizen, and his name has been incorporated, and his name have been shown as the voter with the letter D in the voters list of 2005.
11.
Because the petitioner made inquiries and could find petitioners made inquiry. Okay. The letter D in the voters list of 2005 of village Storol Jhar, district Walpara, LAC 39. So the petitioner made inquiries, but however, no information have been duly provided. It is under such circumstances that the petitioner has approached this court, seeking directions upon the respondent authorities to furnish as regards the pendency of any foreigner's tribunal case, and where such case has been is pending. Then to furnish the number of the foreigner's tribunal case as well as where the case is pending, and or to remove the D against his name from the voters list. The respondents are directed to bring on, I put it on 9, na? Provide instructions as to why the petitioner's name have been mentioned and included, have been shown as the voter, shown with the letter D in the voters list.
Can it be on 13?
Huh?
No, can it be on 13? 13, 1, 3, madam.
1?
Can it be on 13th, my lord?
Why?
My lord, on 9th, there is some difficulty. Can it be on 13 or 6th, my lord? Right.
No, we take it up at 2 o'clock. Get the instruction. You were asked to obtain the instruction in 11/1/2024, 11/11. Does it take such a long time to get that instruction?
6th, my lord.
Whether there is a case pending or not. Find it out. We'll take it up at 2. You wait. I'll dispose it of. Get the instruction. We'll take it up at 2. Yes, madam. You are also squarely responsible for putting the number D. You have done the D. Ask your district election officer. We want it at 2. Why his name has been inserted? If his name has been inserted, there could be 2 reasons. One, it has been either mentioned by the SP, or your person, the verification officer, must have verified and given it, and you have said that, okay, if we find him D, and accordingly have referred him to this the SP voter for the purpose of this. So kindly get this thing by 2 o'clock. We want a disposal.
We can have it in the morning only at night, on 9 10. On ninth, we can have it in the morning itself.
Today is what day?
10:30, on ninth itself.
What is today?
Today, to 20th, on the ninth morning, not the
Today is 2020.
0.
2011-2024 at 2 p.m.
Oh, today.
Today, yes.
Item
Get-
3,
Yes, what is this?
matter pattern not issuing of working order matter.
Huh?
Not issuing the work order matter.
Not issuing you the work order,
Yes, madam. The petitioner
and you have got the contract.
and my lord, letter of acceptance was issued, my lord. Thereafter, my lord, petitioner deposited the performance security also, my lord.
You have given the security also.
Yes, madam.
Yes, why you have not given?
That instruction I have to obtain lordship, but at page 17, lordship may kindly say this is the letter of acceptance. Page 17 and accept the lordship, this is dated 15/3/2024, and lordship may kindly see the last two lines. He has been asked to deposit the performance security within 10 days from issue of this letter, lordship. Now he is saying that this letter was received on 28/2024.
Within 10 days from the issue of this letter of acceptance, valid up to 45 days from the date of expiry of the text.
As it appears, lordship, he should have deposited
In 10
your
days.
performance
And
security.
he has deposited this when?
In
One
August.
8, madam.
21/8.
Now, he is saying that he received this preliminary letter of work order on 28/2024. However, this is his signature, his copy, lordship. I have to check my copy, lordship, when it was issued.
So you say that this 15/3/2024, you received in the month of August?
Yes, madam. They have not communicated, madam. They have never communicated, madam. In fact, my reclamation is also there, madam. Page 19, madam.
That is more subsequent.
Okay. So issue notice, let them file an affidavit. In case of filing. Notice making it returnable on, how much time to file an affidavit? 11 December? Notice returnable on 11th of December 2024. Mr. P. Nayak appears on behalf of the respondent numbers 1, 2, and 3. Full extra copies of the petition be furnished to him during the course of the day. The case of the petitioner herein is that the petitioner, pursuant to a notice inviting tender, e-tender,
Till 9/20.
was selected as his bid was the highest. Highest, na? Ganesh Daimili?
Lloyd Peter,
No, Montunath Bora. Was
Alon Peter.
the petitioner bid was selected. And pursuant thereto, a letter of acceptance was issued on 15/3/2024. The case of the petitioner is that the same letter of acceptance was received by the petitioner only on 28/2024. And accordingly, on 21/8/2024, the petitioner submitted the performance guarantee. It is seen from the records that this court had already by an order dated 6/11/2024, had sought for instructions from the PWD department. Mr. P. Nayak, appearing on behalf of the PWD department, submits that in terms with the letter of acceptance dated 15/3/2024, the petitioner was required to submit the performance guarantee within 10 days, and failing which the respondent authorities have not issued the work order, have not further proceeded with the said bid. taking into account the said stand, this court is of the view that the affidavit on behalf of the respondent authorities would be required for an effectual adjudication of the matter. Accordingly, the respondents shall file their affidavit on or before the next date.
I am obliged. Item 5.
Yes, where is Mr. J. Pang? What is this?
The lordship may kindly see whether the petitioner is the labor, constructed the, uh, the- what is
Non-payment.
pending.
What is
And
this?
by order this.
To make payment of the outstanding earned wages. Wages from where, whom? Yes.
Page 35 may kindly be seen, my lord. I
Page?
approve labor, page 35, my lord.
25.
35, my lord. I approve the labor code, my lord.
Order regarding non-payment
Yes,
case of Sri Ajay Goswami. You Ajay Goswami?
yes, my lord, I am order.
Ajay Goswami.
Yes, page 36 is the finding by the direction.
Labor court. Fishery. As per the order dated
Page 36 direction. Labor official, my lord, this is the direction.
It is given by the labor officer.
Yes, my lord.
Then
Then, my lord, the labor officer transferred, the next labor officer who, next incumbent, my lord, page 37. He has done particular is page 38. I'm, my lord,
so you signed out there.
yes, my lord, I was forced to sign in this document. My
Now
lord.
what do you want?
My lord, your lordship may kindly see, in fact, in the said documents, though it is said this is settled on 25/4/2024.
Hmm.
There is, my lord, noting that the money has been paid on 29/6/24. Thereafter, my lord, after the settlement, what they are, my lord. So my prayer is, my lord, inquiry may be conducted, my lord, on this regard. On what basis, my lord, this is forced, my lord. I have been forced to sign and I have been paid 2,50,000 on.
Well, forced to sign. Forced to sign. So you signed it.
Yes, my lord, that is admitted, my lord, I signed there, my lord.
So how, why did you sign? Did they put
So, my lord,
anything on you?
actually, my lord, what is written there exactly, I don't know. Because he is a, my lord, labor, my lord, he can hardly write Assamese. Your lordship may kindly see the, my lord, handwriting of the person, my lord. He typed, he signed, my lord, page 38, my lord. He can hardly read it in this, my lord. And this is, in fact, some noting shows, my lord, this is letter on written, my lord.
So did you deposit those checks in your account? No,
Wait, 2,50,000.
250,000.
That has been given, my lord.
So
That is given. that-
why,
Not on that particular.
no, when did you deposit those checks? Because the checks were dated,
Yes,
2 lakh was dated 25/4/2024.
Yes, my lord.
And the second is of June 2024.
June 24. After my,
Understood. So these were checks under June 2024. Now, did you deposit those checks?
I have to get instruction on to the defect.
Yeah. There the question arises. If you have deposited those checks, why did you deposit? Why didn't you file an FIR immediately?
I'm not going to, I'm actually, my prayer was, I was not supposed to get, my lord, conflict with them, my lord. But only my.
No, if he was alleging fraud and that to coming before a writ court, whereby this court have to take action against a labor officer, but you couldn't file an FIR? And you yourself deposited those checks of 2 lakhs and 2,50,000 in your account. Why didn't you happen anything? Where is your representation at any point of time thereafter? Anybody? And you have directly approached this court.
My lord, I
Hello,
actually,
we
one of the,
dismiss.
I thought, my lord,
We dismiss it with cost upon the council for wrongly advising the council, the petition. You pay 50,000 to the petitioner from your pocket and 50,000 to the legal service authority. 1 lakh. This is how it is to be done. Why we advised him like this?
my lord,
This is the way. Why you say a fraud has been committed? You are saying a fraud or caution. Why did you take the check? And apart from, okay, you have taken the check. I would have understood that it was a bank transfer. You had no control. You took the check, you deposited the check. And after depositing the check, You let another 5, 6 months go by. And now you are coming before this court that, oh, look here, I want that full money back. Why should we at all entertain these type of petitions?
Then I may be, my lord, allowed to withdraw. I will instruct what my lord.
Mr. J. Payang, the learned counsel submits that he would be, that submits that the petitioner would not like to proceed with the instant writ petition. Accordingly, the writ petition stands closed.
Item 6.
Yes. Yeah, what is this?
Four contract work were done by the petitioners with a bail amount of rupees 11,51,967.
Non-payment.
Non-payment.
When?
The proposal was submitted, my lord, demand proposal was submitted on 9th of 11, 2022 and 7th of February 2022. Just 2 years, man.
How much amount?
11,51,967.
In different contracts.
Yes, four contract, 4 war contract.
I hope notice making it returnable on. Writ petitions for contractual works will go for some time. Issue notice making it returnable on 5th of February 2025. Mr.
Yes, sir.
S.R. Bolu appears on behalf of respondent number 1 and 2.
Two, I am not appearing, Lord.
Why not? Principal Secretary, Assam Legislative Assembly,
Standing counsel is there.
and you are appearing for the Commissioner and Secretary to the Assam Legislative Assembly.
Department I am appearing, for the assembly, they have some separate standing counsel.
Who is it?
If we are
If we are for Assam Legislative Assembly.
assembly.
Where is he? You have not served.
I have submitted.
You are there in his office.
On behalf of Mr. A.K.
Is he around in Guwahati in the court today? How will you call him? Okay. Okay. Appears on behalf of the respondent number 1. Mr. P. Nayak appears for respondent number 3 and 4. Kustam. None appears on behalf of the respondent number 1.
On behalf of Mr. A.K.
So and so represents the appears on behalf of the respondent number 2. Ito ठीक कोई नहीं, हाँ? As the respondent numbers 1 to 4 are duly represented, extra copies of the writ petition be served upon them during the within 3 days. The case of the petitioner herein is that the petitioner is entitled to have carried out various works.
For what?
Have carried out 4
Contract work.
contractual works.
Some legislative assembly. Page
in the 4 contractual works.
Page 13 is the first demand proposal, my lord, in respect of the first work. Then second one is page 19, my lord, in respect of 2 contract work, which is a demand proposal, common demand proposal. And page 31 is the
No, Mr. Counsel, first of all, why don't you categorically properly mention which are the 4 contractual works?
I have mentioned, my lord.
We should dismiss your petition on that ground itself. On the ground of misjoinder of causes of action.
My lord, I have specifically stated, my lord, in
Why? Why it has not been specifically? Which are the contractual works?
para 3 of my petition contains to the first work order.
Where is your contract?
My lord, page lordship may
Where is your contract, work order?
page number 17 is the first work order.
17 is the first.
First.
Number 2 is which one?
Number 2 is, my lord, page number page number 24, my lord. It is in respect of an amount of rupees 1,69,933. Then, my lord, third work order, page 29, my lord.
2017, 24, and the
29.
next one,
29.
29.
And my lord, the last one is my lord, case 34.
Page
34.
four. Case of the petitioner herein is that the petitioner was issued 4 work orders by the Executive Engineer PWD Guwahati Electrical Division in connection with how is it connected? Oh, this was because of the budget session.
My lord, this was the work model for temporary installation of CCTV at supermarket, police barricade area, and Dhorna ground and social VIP road. Well, it was done during the budget session of 2022 in respect to first work order. And second work order was allotted, my lord. It was for my
Understood.
lord,
Why you are making the Legislative Assembly a party?
because my the works was done allotted by the Assam Legislative Assembly, Principal Secretary,
Where?
Assam Legislative Assembly,
Where? Show me.
Lordship. The administrative approval, my lord, your lordship will find page 14, my lord.
I issued 4 work orders by the Executive Engineer PWD Guwahati Electrical Division for the purpose of installation of temporary CCTV at various areas as well as renovation of certain electrical installation at cottage number 9 of the old MLA hostel. The petitioner claims that the petitioner is entitled to an amount of rupees 11,51,967. However, the said amount having not been paid, the petitioner has approached this court. The respondent shall bring on record the stand as regards the petitioner as entitlement by filing affidavits on or before the next date.
My lord.
Item 7.
Yes, what is this?
Your Lordship, matter pertaining to non-payment of contractor bill. And page 17 is a liability statement. Lordship. The admitted amount.
How much? From whom?
7,700,300.
From whom? From whom will you be entitled to? Water resource.
Water Resource Department.
What did you do?
Lordship, it's contractor with the Water Resource Department.
Are there anything to do with the Jal
Jal
Shakti?
Shakti, Lordship, it's a
Then
party.
Jal Shakti not made a party?
Yes, Lordship, but one and.
Oh, one. You are there?
Lordship,
You are there for Union of India? To notice making it returnable on 12th of February 2025. Miss So-and-so appears on behalf of the respondent number 1 and 2. And Miss So-and-so appears on behalf of respondent number 3 to 6. The petitioners herein And as the respondents are duly represented, extra copies of the requisition be served within 3 days. The petitioner herein claims that the petitioner is entitled to an amount of rupees 70,07,387, which is an outstanding, which is on account of various contracts carried out by the petitioner for an on pursuant to orders, pursuant to formal work orders being issued. It is being aggrieved by the non-payment. The petitioners have approached this court. The respondents are directed to bring on record their stand as regards the petitioner's entitlement by filing their affidavit on or before the next.
Item 8 similar. Item 8 is also,
How much is the amount?
that one is Lordship 4 lakhs. 4 lakhs 55,000.
Same persons.
Petitioner is different. Respondent are same.
How much is the amount?
4 lakhs.
4 lakhs?
55,163. That is at page 17, Lordship.
Four lakhs to you, huh? Baki naam ki type you. One contract. How many contract?
So there's, work order is same, Lordship. There's 7 various contracts.
Okay. 4 lakhs. 4 lakhs amount to salary.
That's it. Outline.
Item 9.
Yes, Mr. Siddharth.
My lord, here this petitioner has been made devoter in 1997. And he is regular voter in 1989. 89, he is regular voter, but 97 he has been made devoter without hearing him.
Then
And he has submitted representation before the election officer in Excel 16, page 53.
Then
No step has been taken. My lord.
nothing. You became a devoter when?
97, my lord.
What were you doing all this while?
My lord,
What is your age?
my lord.
55.
Yes, my lord.
So 97. 97 is 27 years back.
96, no, in the year 1997.
That is it. 27 years back.
Yes.
So 27 years back, you have not voted for last 27 years. And why do you want to vote now?
My lord, she has been made devoter without hearing, my lord. So she is pursuing.
You only can't vote. For last 27 years, you have not voted. Meaning that with 55, you are now 27 at that point of time. And you last voted in 89, which means another 8 years, 55, 27 and a year. That is the first time you have only cast vote only once, 18. Then you are not
First MP.
bothered.
My lord,
Why?
no,
Why?
my lord, at this stage, my lord, the petitioner citizenship has been doubted.
So very well.
So
You can be only thrown out with a formal foreigner's order.
They let that may be done. Let the reference may be made against her, my lord. And we will contest. That is your contention.
It may be a case where the reference has already happened. How do you know?
She has inquired.
By filing this petition, it may be a plea that you are coming up before this court saying that I didn't know. And order being passed out here will be a testament that I had no knowledge. Then
He was marked without her.
why didn't you wake up for the last 27 years? They just wake
My lord, without demarking in 27 years back, my lord, by that marking, she has been my lord, her citizenship may be curtailed forever without giving any opportunity, without any process, my lord. The process is, my lord, that should be
It
an
may have
application.
been that the foreigners tribunal may have decided everything. Now you must have come to learn. And now having come to learn, file a writ petition out here, then this becomes a added proof that you have no knowledge. What do you say, Mr. Pan? Isn't it such an easy thing? All this while, what were you doing?
My lord, these people, my lord, they are actually not so much aware about the status as a citizen, to what is the meaning of the voter, and ultimately she has been.
But they didn't care to vote. You came within the ambit of that 1997 order, wherein around 4 lakh people were made the voter. Then these recent voters are being marked pursuant to Justice B.K. Sharma's order. Anybody's case is pending in the Foreigners Tribunal, then you make it. But you come within the ambit of that first revision which had been made, wherein you have been made the voter. 97.
Well, therefore, my lord, she is before lordship, my lord. Let the authority be directed to initiate a process.
Why? If the process has already been initiated.
No, my lord, it's only marking D, my lord.
How do you
Tribunal
know?
has not decided
So
it.
you know everything. Why didn't they approach this court for the last 27 years? Hello. Basic in notice issue. Issue notice making it returnable on 14th of February 2025. Union? No union. You have not served a copy on the union.
Copy, my lord. So, serving copy.
You are union.
Yes,
When so appears on behalf of respondent number 1. Mr. S.R. Bolwe appears on behalf of the respondent number 2, 3.
I'm appearing for 2, 5 and 6. 2, 5
Two.
and 6. Yes,
Okay.
I'm appearing for 2, 5
Appearing
and
on Mr. J. Pang appears on behalf of respondent number 2,
5 and 6.
5 and 6. Mr. S.R. Bolwe appears on behalf of the respondent number 3 and 5. Oh no, 3. And Ms. T. Bolwe appears for the respondent number 4. Why you're not making the chief electoral officer?
well, election officer.
Who is this election officer? Tell me. Let us also be knowledgeable. How can there be an election officer? There can be a district election officer who will be doing it, the marking of D. Why haven't you make that person a party?
My lord, election officer.
Election officer, who is an election officer? Tell me. We only hear about a chief electoral officer, district election officer. Electoral officers are just multiple officers. Can you ask this court to ask him to remove it? No. The election commission should have been made a party. Taking into account all the respondents are duly represented, extra copies of the petition be served upon them within 3 days. The case of the petitioner herein is that the petitioner had been marked with the letter D in the year 1997. And the said marking of the letter D, which the petitioner came to learn only recently, the rights of the petitioner have been taken away without due process. The respondents are directed to bring on record their stand by filing an affidavit. Maintainability on the ground of latches is kept open.
Yes, yes.
Yes, what is this?
Nothing matter patterns to non-payment of contractual bill lordship. If work order is at page 12 lordship.
How much? 9 lakh
9
99.
lakhs 99. 9,99,932 rupees. Completion certificate and liability certificate is at page 13 lakhs.
Notice making it returnable on 14th of February 2025. PWD, who is appearing?
3 to 6. 3 to 6. 3, 4, 5.
Who appears on behalf? No, who appears for PWD?
Mr. P. Nayak.
No, PNAC. Mr. PNAC appears for respondent number 1. Finance, PNAC appears on behalf of the respondent number 1 as well as for respondent number 2. And so appears for respondent number 3 to 6. As the respondents are duly represented, extra copies of the petition be served upon them within 3 days. The case of the petitioner herein is that the petitioner have carried out certain contractual works and completed the same. However, the payments have not been made, and as such, the petitioners have approached this court. Petitioner has approached this court seeking an appropriate redirection and order. The respondents are directed to bring on record their stand by filing their affidavit as to whether the petitioners are entitled to the amounts so claimed.
11.
Wait. Here, madam, I'm agreed by non-acceptance of my technical bid, madam.
Huh?
I'm agreed by non-acceptance of my technical bid. Pursuant to tender process, I have submitted the online technical bid, but under clause 6, I required to submit some document physically. So I am a contractor from my lord, Hilshire, my lord. Sorry, Hailakandi, my lord. So on 2nd of November, I have submitted my online bid, my lord. My lord will find it at page 25 annexus C.
What is the contract for?
This contract for construction of roads, my lord. Page 19.
Now, page
Page 19, my lord.
30 numbers of
30 numbers
construction
of-
of roads in tea garden areas.
Yes, madam.
Total is 47.83 crores.
I have
So you
participated for
participated.
package
You
number.
participated for all.
I have participated for package number, package at serial number 16 and 18, page 21.
16 and 18.
Yes.
Is, what is that?
For the
16
district of
and
Hailakandi.
18. It is from Salsapara, PWD road to
Sahapur, PWD
Sahapur,
road.
Sarapur, PWD road. Other is from Oria
Oria
labor
labor
line
line
to Tea
to Tea
Garden
Garden
entrance.
entrance.
So these are the two roads.
Two roads, my lord.
Total bid security demand, total processing demand, total estimated 161 lakhs and 100 lakhs. 1 crore and 1.61 crore. Then what happened?
So, my lord, kindly come to my lord, page 23. There is a clause 6.
Because
The bidder must submit a hard copies in original of the following documents on or before 5/11/2024 up to 14 hours, without which the bid will be rejected. So
Hmm.
this is the requirement under the contract tender to submit hard copy of some of the documents in physical mode, my lord.
then
Page 24 is the, my lord, time schedule, tender time schedule, my lord. Bid serial number 8, bid submission closing date 5/11/2024. Page
to 2.
25,
So by 2 o'clock,
yes,
you
by
have
2
to
o'clock.
also submit the hard copy.
Yes, my lord. I have submitted the online on 2nd of November, page 25 and 26, the acknowledgement.
Uh, At what time?
At my lord, 7:35 PM.
Huh?
This
Then
is-
what happened? Oh, this is on
online,
5th.
this is online, my lord.
Okay.
So,
On 5th.
then, my lord, I have booked my ticket, page 27, my lord.
Then
On
the
3rd
flight
of
will not
November,
go.
I booked my ticket to
Oh.
train, my lord,
Uh,
from Badarpur to Guwahati.
Oh.
Boarding from Badarpur, the time is 11:55.
Then what happened?
But my lord, due to some delay in arrival of train, my lord, I reached Guwahati on
No case.
5th of,
No case.
that's the only reason they have not accepted my,
Absolutely, rightly so.
my lord, because of delay, there are some,
They have a term out there. Why we, everybody will come up with all these things, rightly so. No case.
I have booked my ticket on time.
So what?
My schedule arrival was.
You should have come 2 days before. You could have filed the online on second. Why did you wait for fourth evening night at 2:30, 23:55?
But my lord, one
You
thing
know the trains. You have been to.
they will, my lord, accepting my bidder, well, they will not be prejudiced.
No, absolutely no.
Yes, my lord. They will not be
Question is when the tender stipulates something to be done in a same manner, it has to be done. Otherwise, giving you one liberty means giving all others a liberty.
But
What do you say, Mr. Nayak?
Yes, Doctor. Doctor, may kindly see that clause lordship at page 24.
6.
Yes, it's specifically mentioned, Lord.
I've seen it.
That is why, my lord, I have come before this honorable court, my lord, because there was a specific requirement under the
Dismiss.
under the NI.
Withdraw. Which one? This is not
In-
a fit case even to issue a notice also.
In fact, my lord, page 19. Page 19, my lord. Kindly have a look, my lord, page 19.
What is that?
Schemes are not yet sanctioned by the competent authority. This scheme for the work
Huh?
has not yet been sanctioned, my lord.
So what?
Because that is all, they have not urgency. It's not
So what?
not
It
a
is
case
not
that-
a question of urgency.
That I
It is a
understand,
question of
that I
the term of the tender. Why should this court interfere? This court is not a court out here to be a case of giving charity or doing anything to the effect that,
Because
okay,
while
we feel bad
while
for you,
late
your
because-
train did not come.
because my late arrival is beyond my control, my lord.
So what?
That
Why
is-
did you book the ticket on 23:55 at 4 on 4th? You should have come 1 day before.
Because, my lord, I got the reservation on 4th of November, my lord.
So come by bus. And you have come from Silchar,
Yes, my lord.
nearby. Hello, dismiss. Heard Mr. N.J. Khatania, the learned counsel appearing on behalf of the petitioner. Mr. P. Nayak appears on behalf of the respondents, PWD department. Full stop. The petitioner herein is aggrieved by the rejection of the petitioner's technical bid for not accepting the physical copy, for not submitting the physical copies of the documents within 2 p.m. of 5/11/2024. Full stop. It is the specific case of the petitioner that the petitioner could not submit the bid, the physical, it is the specific case of the petitioner that the petitioner had duly submitted the online bid on 2nd of November 2024 at 7:35 p.m. However, the train by which the petitioner was traveling from Silchar to Guwahati,
Hailakandi,
Huh?
Badarpur to Guwahati, my lord.
Badarpur to Guwahati, and was supposed to arrive at 8:45 a.m. on 5th of November 2024, arrived at 5:02 p.m. on, isn't it 5:02?
Yes, my lord.
On
5th of November.
5th of November. And as such, the petitioner's bid ought to have been, the physical documents ought to have been accepted and the technical bid ought to have been considered. Mr. P. Naik, the learned counsel appearing on behalf of the respondents, drew the attention of this court to the notice inviting tender and more particularly clause 6 of the note, wherein it had been categorically mentioned that the bidder must submit hard copies in originals of the documents mentioned in subclauses A to E on or before 5/11/2024 up to 1400 hours, without which the bid would be rejected. The learned counsel appearing on behalf of the respondent submitted that the petitioner very well knew the said aspect of the matter, and having not submitted the physical bid, the petitioner having not submitted the documents in original, the documents specified in subclause A to E of note 6 of clause 6 in original, the petitioner's bid was rightfully technical bid was rightfully rejected. This court having heard the learned counsel for the petitioner as well as the learned counsel for the respondent, having given an anxious consideration to the same. This court further takes note of that clause 6 of the notice inviting tender had made it specifically clear that the bidder must submit the hard copies in originals of the documents mentioned in subclauses A to E on or before 5/11/2024 up to 1400 hours. The petitioner having admittedly not submitted the bid, the physical documents, the hard copies of in original of the said documents on or before 1400 hours on 5/11/2024. The petitioner, admittedly, the petitioner did not submit the documents mentioned in subclauses A to E of clause 6 on or before 5/11/2024 up to 1400 hours. Under such circumstances, the rejection of the technical bid of the petitioner was justified and cannot be said justified and does not call for any interference. Accordingly, the writ petition stands dismissed.
Item number 12 and 16 is similar one.
Same, all came like this.
All are from both Hailakandi, madam. They are coming by the same train, madam.
You file a compensation case against railways, then we find another Mr. The central government councils.
13.
Obliged.
What is this?
Yeah, please, my lord.
Not.
My lord, we have filed a representation to the GMDA and GMC against the illegal construction.
For what?
My lord, this is a undivided property, my lord. My lord, may kindly come to page number 38. my lord.
Not be issued to stop the illegal construction of G+1. Yes, why you are asking illegal construction?
My lord, may kindly come to page number 38. This is a notice which was issued by the Chief Executive Officer of GMD itself. They said that 38, my lord, page number. Where you had
You have
not,
not produced the NOC from the
Yes,
Patadar, in spite of the fact that the land is under Ajmali Patra and therefore NOC is compulsory from the Patadar to develop the land and for permission of the building. What does this GMBA have to do with all these things?
my lord, since there is a process,
They are not to see as to who builds where. They are only to see whether it is in accordance with the building plan.
yes, madam. And to obtain that particular building plan, my lord, we need to have a land.
Nowadays, they can get a permission from GMC online also.
My lord, for that, we have to comply with the rules and regulations set by. the
No,
GMC.
no, not necessary. You apply now, you get it in 15 minutes.
My lord, since there was a stop construction, even
And G+2 is permissible, no problem.
so G+1, there is a problem with it, my lord. My lord, may kindly see the photograph that I have attached. Since as per.
Who are
the-
you?
My lord, I am the one of the co-patadar.
Why are you not filing a suit? What is all these things?
Hello?
No. You have a problem with him. Why you are roping the GMC?
My lord, when we
Again,
have given a complaint to the GMC, GMC has also issued a stop construction. Meaning they
Whatever
have.
maybe, why you are not filing a suit? You have a Ismaili Pattada. You are also,
Yes,
you
yes,
are a co-Pattada.
yes, my lord.
So why you are roping the GMD or anybody, all these things? They have no other business. They have better business. They will provide you better water supply and all, or sanitation better to do than going into all these private disputes.
My lord,
Nothing doing.
I came up,
It's a, this is an abuse. What do you say, Mr. Nayak? Abuse?
Basically, it is their internal issue.
Absolutely. No, let them file a suit. And I would have understood there is a violation of a building plan, building bylaws, and all these things. We understood. But here is a case that the Pattada's, co-Pattada's objection was not, no objection was not taken. Right? This is absolutely within a, the GMC should not have. Go file civil suit.
even as per the notification.
No,
of the
Mr.
GMC, my lord.
Civil suit. Forget about notifications.
My lord, we have also come,
We are
that
not
there is a violation
concerned.
of Article 21.
Civil suit.
My lord, we have also come before this
Chalo,
honorable court
abuse.
on the ground that there is a violation of
50,000.
Article 21.
Abuse.
Lord, may kindly see the photographs that we have annexed.
I'm not going to look into anything.
Because
Is it-
I am also
You
checking.
have to have file a suit. You can't take all the
My
advantage.
lord, that part is there, but my lord, what I'm saying is,
Nowadays, you see, you can tell me what is the role of the GMC or GMDA
yes,
in respect to taking no objection certificate from the co-pattatar? Tell me. Tell me.
what
If
I'm
he is in occupation of an Esbali Patta, he has a right out there. If there is a dispute as to whether he should have a right or not, file a civil suit. What is the GMC or GMDA going to look? Does the GMC or GMDA have the authority? No, okay, we are not going to give. If he shows that yes, I am a co-pattada having my right over this, I am also in possession of this, so I want to construct here. GMC, if it is only going to see as per the as to whether it is as per the building bylaws or not.
my lord,
Show me where is the infraction to the building
my
bylaws.
lord, may, this is a notification, my lord, which is
Notification, no.
of the
Building
GMC
bylaws.
bylaws, my lord.
Bylaws.
Bylaws.
Where?
Where in, page number- I mean, this is about the planning parameter for planning permits, my lord.
Yes.
Here, my lord, may kindly see the weight of existing road, the box that I'm referring to, and the weight of the proposed road. My lord, weight of the existing and the proposed street line shall be prescribed in the master plan for the city of Guwahati for roads where proposed road width is not indicated. It shall be as follows. My lord, there is a note which is written that this will not be for the private roads for authority. My lord, if you go-
Where?
my lord, in the last line, just below the box.
There will be
Start.
not be for private road. This will not be for private road. Kadesic for authority will decide the width based on area from dead road up to Iman instance. What is this?
My lord, the next page, if you come for the planning regulation, next page, front setback and the side and the rear setback. If I go through the pictures that I have annexed, my lord, even while constructing this particular building, this particular provision which is laid down here was also violated.
Front setback. Front setback should be
Yes,
how much?
based on the height of the building, my lord, more than 6.
You are referring to which building at page 35, 25 of your writ petition?
That is not the complaint, Lordship. Complaint is at page 29.
I'm referring to the under constructed one.
Under construction. And the next is yours.
Not, next is not mine.
Why you are
Then
not complaining
this-
against
the
him?
road which is been.
Why you are not complaining against the
My
other
lord,
one?
there is already a.
No. Why you are not complaining against the other one? The other one is more. Doesn't have the more. It is more. The height is much more. Why you are not complaining against the other one?
Because the GMC have already filed a title suit against this particular construction that it has gone illegally as per the rules. And already the case has been, I think maybe it has been.
Absolutely. Case of this. Yes, Mr.
My lord,
Naik, you are showing
produce
something.
the case
Request
number.
for not granting permission of construction in respect to a plot of land measuring 1 katha covered by so and so. So and so was the owner of the land, so and so after that I became, getting to learn from level social the legal help of him trying to construct. Or in the process. Land. So- We dismiss your petition.
My lord, may kindly consider one thing, the roads through
Or
for which,
Mr. K. No, absolutely no.
my lord, I have also approached under Article 21, where I say that my right to life is also been violated.
What is your
because
right to
for-
life?
My lord, if I go for Article 21,
What is right to
From-
life here? What is your right to life here? Tell
lord,
me.
yes, my lord. I'm saying that under Article 21, life should not be just like an animal existence. That's what I'm trying to show. The proper sunlight and drainage system. If I go with the preamble of the GMD Act itself, what they say, my lord, if I go with the GMDA Act 1985, the preamble says that where it is expedient to provide for the establishment of the authority for the enforcement and execution of master plan and for formulations and execution of scheme for the plan development of the Guwahati metropolitan area for coordination and supervision of the co-execution of the plan with the object of securing proper living and sanitary conditions to converge and promote public health, safety, and general welfare of the people living therein, and for matter connected therewith or incidental thereto. And this is the preamble of the GMDA.
Where are you staying?
My lord may see the road which is in between. I'm staying behind that.
Where?
My lord may kindly come to page number 26. This
20?
is the route through which I enter between the two buildings.
Where is your building?
My lord, my house is behind 27.
Page?
Page number 27.
Which house? This house. How do you go here?
My lord, that the road which is actually basically a drain between the two buildings is
Oh,
the
this
road of.
one.
Yes,
This
ma'am.
house with the meter.
Yes, ma'am.
This is your house.
That is my house.
Then why don't you cut to your tree? It will give you more sunlight.
My lord, once the building is up, my lord, the height of the
Why the
building.
building will be up? The building is G+1. Why you are not saying anything about the earlier building?
My lord, there is already a case pending because the GMC has filed a case against the particular owner of the.
I'm not concerned with all these things. Why haven't you filed a writ petition as against the other that he's trespassing
once
upon
we-
your right?
Once we give the.
Go for change out there. This can't be there.
My lord, may kindly consider one fact that once I gave the complaint, GMC took action. They gave an stop construction notice and they have challenged that particular notice.
And the house has become so much and now you are asking for demolition.
My lord, may consider one more thing that on the year 2023.
Cost.
My lord,
Now
my
this
lord,
is
when
a
the
case
year
of cost.
2023, when the building was started, then I have given the complaint. Then the stop construction notice was issued by the authority. And on violation of this stop construction notice, now they are continuing with the construction. That is the vital fact. Means once I have approached the authority.
For that, the GMDA knows what to do.
My lord, the GMDA has to come.
GMDA knows what to do. If
lord.
there's a stop construction or anything, they will know. Why should this court initiate,
Because,
direct them?
my lord, they are not taking any action against. it,
Heard
my lord.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. Inayak appears on behalf of the respondent numbers 1, 2, 3, 4, 5. Full stop. The case of the petitioner herein is that the petitioner herein has filed the instant writ petition seeking a direction upon the respondents, the respondent authorities. To stop the illegal construction of the G+1 RCC building constructed by the private respondent number 6 and 7. And further, why the respondent authority should not be directed for demolition of the illegal G+1 constructed RCC building. Full stop. This court had duly perused the materials on report, including the representations so submitted to the Chief Executive Officer, GMDA, the Commissioner, Guwahati Municipal Corporation, as well as the Associate Planner of the Guwahati Municipal Corporation. From a perusal of the said communications, representations, it transpires that there is a private dispute between the petitioner as well as the respondent number 6 and 7 as regards the rights over the land wherein the construction is being carried out. Full stop. It is under such circumstances, the petitioner, full stop, this court having full stop, it is further seen that the petitioners, on the basis of their of these however, instead of settling those disputes through the court of civil procedure, before a competent court of civil jurisdiction, the petitioner has invoked the writ jurisdiction of this court and thereby to compel the statutory authorities to take steps against the respondent number 6 and 7. In the opinion of this court, the said manner in which the petitioner is seeking to exercise the jurisdiction amounts to an abuse of the process of the court, and for which the writ petition stands dismissed with cost imposed to the tune of rupees 50,000. 25.
I'm just praying that because Article 21, because since.
Not at 21. There's no 21. 21, don't come up with these type of arguments of 21.
Because
21 is better. Use 21 for a better purpose, not this type of matters.
Not submit that.
My goodness, you have all the sunlight out there. Why you are not saying anything about the front of the building? You are not. The
No.
29 is on this side. There is a building, and because of that, the sun would not come. So you have.
the drain, if Lordship has observed that, my lord, that is the drain of these two buildings. So where my ingress and egress path is.
So-
I'm saying that, my lord, it is an,
Therefore, you need to file a suit.
my lord,
Yes,
since.
sir. It is however observed that the dismissal of the instant writ petition shall not preclude the petitioner to approach the civil court, if so aggrieved. First of the observations made herein above would also not affect the petitioners in such proceedings so initiated. Try to get something there, but with this thing, you won't get anything. Better withdraw. Whenever counsel appearing on behalf of the petitioner submits that we be well advised to take steps before the authorities concerned, and such the petitioner would not like to press the mistake. In view of the above, that said, the petition stands.
I would like-
This is a better one.
The page 31 make and list. This is a finance department, government of India's finance department. Instead of, for the purpose of performance security and the amended rule, there is a provision for providing insurance bond in place of manual bank guarantees. So the petitioner has been given the contract. He is required to give manual bank guarantee for the purpose of this performance guarantee, but in view of this office memorandum and also page 36.
Tell me, what is the case about?
The petitioner has been given the contract and he has accepted the letter of acceptance at page 25.
Letter of acceptance.
Yes, there is a requirement for providing performance guarantee. Second paragraph, my lord. And performance guarantee, my lord, we are required to give bank guarantee and all.
The form of-
Page
in-
29.
Form is given in clause 4. Equivalent to 5% of the contract amount, the tune of 30 crores and so on. So these were 28 from the date of. Yes.
Three crore 88 lakhs, when we are required to give bank guarantee. And page 28, well, this is the standard general conditions of contract. Railways, page 29 is the relevant. Last portion, well, 16(4)(b). Last for 3 lines. Successful bidder shall submit the performance guarantee in any of the following forms amounting to 5% of the original contract. Bank guarantee, etc. All these things.
Then-
Now, there is a page 31. There is a provision made by the Finance Department, Government of India, that instead of performance a bank guarantee, you can provide insurance bond. That page 31 is there. And all, most of the public enterprise, I have given here, example 3, that they are providing that you can give insurance bond instead of bank guarantee, etc. Now, page 36 is the OM also. This is the amended rules, page 31. Well, the second portion is relevant to me. Performance security may be
Now,
funded.
these 1 to 11 does not include insurance security bond.
No, it doesn't. It doesn't, but the office memorandum, Government of India's office memorandum is there. It says instead of bank guarantee, you can provide insurance bond. Now, page 36, my lord. 36, that office memorandum is also there. It says, my lord, may I just read this, my lord? This is to inform that insurance security bond is envisaged to be a viable alternative competent to bank guarantee, aim to offer the benefit of freeing up working capital of contractors, which otherwise is locked up as collaterals in lieu of obtaining BGs. ISBs are instruments where insurance companies act as surety and provides the financial guarantee that the contractor will fulfill his obligation as per the agreed terms. Last paragraph. Against the above background, it is requested to explore bid and performance guarantee bonds and to adopt and promote the use of surety bonds in project related to your ministry. Now, I have shown, my lord, that page 37, 38, 39 in respect of National Highway Authority, EPE and CPWD. They have adopted this principle, even the yes. Even railway in EPC tender, my lord, have affected this. So what I pray, my lord, we have given representation, they have not considered it. Let them take instructions what are they doing. If they do not accept it, I'll have to pay bank guarantee.
But now you want to give insurance.
Insurance bond, we have given them representation, 3 representations have.
So why didn't you, at the time of submission of your tender, did not say that this term kindly include the insurance bonds? You could have very well mentioned.
At that point of time, I did not say, but I have.
No, then why should we exercising 226 should incorporate
But
something?
since the ministry's provisions are there, so what I pray, my lord, let them take instructions whether they are giving it or not. If they do not give, my lord, I'll have to give bank guarantee. I'll give it, my lord, but they say I have given representation, they are, if you want to consider it, my lord, in respect of the same board.
But
my
your
lord,
period is going to be over, 60
No,
days will be
60
over.
days I'll have to pay some interest and all. I'll
No,
pay. After six, that is on 24.
no, after 21 days is over.
Yes,
Now you have to pay 12% interest
20
additionally.
yes.
Plus
That I'll have to pay
60 days it will be terminated.
24/11. That will come.
24/11. Then
We have this, so that he can take the instructions, man.
When I've taken the instruction, what the, since it's a policy decision has to be taken, Malad, and has to come from the railway board. And the instruction which I have received, Malad, is that no such guidelines have been issued by the railway board till date. And Malad, in the contract, at page 29, the form of the bank guarantee has been clearly specified. And the letter of acceptance was of 24/9, my lord, and the circular is also of 24/9. Perhaps, Lord, it's a policy decision which will come later on. But at this point of time, my lord, that direction cannot be given, my lord.
we can decide this issue as to whether it is none, but that will be taken as a theoretical issue without going into the question your termination will happen.
We should not pay the bank, the form of bank guarantee only, otherwise.
So first of all, therefore, you should have at that point of time said, at the time prior to this, you should have said that kindly take the insurance. These things have come later on. Office memorandum, this is by the director insurance,
It has to come from the railway board.
Ministry of Finance. Without the railway saying anything, it can't happen.
This page 38, my lord, page 38 is also railways. I have not given, my lord, they have accepted it. Performance security, this is in respect
What
of
is this?
EPC, my lord.
And it is provided, my lord.
Engineering,
In this
procurement
contract,
and.
it is not provided.
Engineering, procurement and constructions.
What is
EPC tender,
DOC?
EPC tender is engineering, procurement and constructions. This is part because the whole thing we did not get it. They have accepted this. Within 30 days of the issue, whether they selected bidder shall punish equal dear.
It is by the NF Railway.
Yes,
That is provided in the contract, my lord. Where in the contract, the form of
no, this is
bank
the,
guarantee is specifically provided. You know, the contract, the authorities cannot go beyond the contract modifying their own tender conditions.
no,
or to take any
saying
other
that,
form.
what I am saying, my lord, submitting for this court, my lord, let them take proper instructions in the matter, whether vis-a-vis page 38, whether this can be done or not. Because ultimately, my lord, Government of India's, my lord, Government of India's main purpose is that for the purpose of freeing up this working capital, they have made these provisions. So if they apply their mind, whoever the authority is, my lord, let them come to a conclusion.
But you were filed at the last moment.
My lord, because, my lord, we came to know all these things at a later stage.
You came to know on 24th of September.
But
when it
the
was there.
Notification was there, 24th September, the notification.
So,
And that is the date
24th
when we
September, you
accepted.
came to know and you submitted these communications on 25/10.
Yes,
Why have you approached 30/10? Today we are just 20, 22, 24 is on Sunday. So by 25th you have to submit. How can he get any decision today too early?
The authorities will not be able to decide. It has to come from the railway board, one of the circulars have to be issued.
We can issue notice making it returnable on 15th of February,
February.
12th of February 2025. In the meantime, I give you the liberty to deposit whatever maybe and they will take whatever decision. And after we'll see if the issue alive, whether irrespective of AI, the bank will be doing some good service for the NF Railway for a later point of time.
But good service definitely will have to do, my lord, if they do not accept it. But my only concern before
You should have come immediately.
yeah, that I'm delayed, but I have.
Means to allow such a thing to
Para
happen
13,
today.
your lordship will can be seen, that's para page 13.
What is the benefit of an insurance bond security?
Insurance bond means, this is what I understand. We'll have to pay about 38 lakhs to the insurance company. This money we will not get it back. Like the bank guarantee, we get it back. Yeah, but the bank guarantee of 88 lakhs is a working capital which will be blocked. And yeah, I'll get it maybe after my working, completion of the working, then on this defect liability period, etc. The main aim and object of the finance department is to, for the purpose of enabling the contractors to perform their duties when not in a with much easy manner. So here I pay 38 lakhs to the insurance company.
So
This
that
money
means
has
you are
not
not
get back.
accepting.
Hello?
You are not accepting the letter of acceptance.
No, we are accepting.
No,
We
because
have
it
to pay.
says letter of acceptance is subject to payment as per 16.4.
Yes.
Now you want to deviate from 16.4.
No, that's what I prayed before them. They should, if they are not accepting it, my lord, and if I do not get some sort of, from your lordships, protection.
So why
from the
should I
lordships.
give them, allow them to deposit this insurance bond? Because insurance bond means how do they liquidate it tomorrow?
The insurance company will. Insurance company will. That guarantee part, whatever is there, the insurance company will provide. That 38 lakhs gone, just like my bank, my premium, in respect of car. If something happens, the insurance company. Entire security is taken. So this is the purpose of the Ministry of Finance. And this has been done at the instance of the many representation from the contract. A huge amount of bank guarantee is blocked.
We can decide on the representation within
Hmm?
4 days, we will decide on the representation.
Then what happens? How will the 60 days thing will happen?
Before, we
They will decide and then we will say no. We will obviously say no. But what is the impact?
Your lordship will give us 7 days time. If they reject it, I'll have to pay.
already, I have issued the inspection.
Because there again, it will go against this LOA has been issued exactly in terms with 16.4. I will say 16.4, categorically say 16.4.
29.
And further, if 60 days happens to have been declared a so and so, yeah. In other cases, the fails to deposit the PC even after 60 days from the date the contract is liable to be terminated.
Yes.
In case contract is terminated, he is entitled to forfeit the bid security and other dues to the contractor against the particular. This is a major issue. It will
Major
happen.
The memorandum also come on there.
In fact, even the contract has to provide for that.
And this memorandum at page 36, my lord, it has page 36. It has come in, come into play my lord,
No,
on the same.
Mr. Das. How about an order to that effect? To deposit the bank guarantee and submit a representation for acceptance of the insurance bond, which you have already done, that would be considered, and upon consideration of that, if they permit you to take the insurance bond, then you can take away the bank guarantee and deposit the insurance.
That should work, my lord.
That I think may, because you have come at the last moment. To deposit, you have to save your contract also.
Yes, yes.
So you save your contract by depositing the bank guarantee, and your representation shall be considered by them, taking into account the ministry's circular, and subject to the outcome of that circular, or the representation, you may then deposit it and take the replace of the bank guarantee. I think that is, I think maybe the right,
So that they.
so that the
Decide the
railways
matter.
also, you can say, there's no problem. And taking into account the finance ministry's circular,
And also the enterprises which are following you.
understood, circular, they will take a decision, give them some detail, because this is a contract for 3 years.
Yes, you have to say.
So in the meantime, if the ministry takes a decision, then the petitioner will be at liberty to withdraw the bank guarantee and submit. I think that seems to be a fairer thing, isn't it?
Absolutely. Absolutely. Well, they will also take into consideration.
No, those I'll reflect it and dispose it of now. This is the best way out.
I think.
Because you have to save your contract.
Bank guarantee will not within this stipulation.
No, they'll deposit the bank guarantee, and you consider representation taking into account, and also you may take some time. Take some time, because in the meantime, the Ministry of Rail, also the railway board may come up. So if they take a decision, then the petitioner should be afforded the benefit of that for withdrawal of the bank guarantee and depositing the
They will
insurance.
take the decision within period of 2 weeks.
I think this is the. Heard Mr. B.D. Das, the learned senior counsel, assisted by Swansea, and Mr. H. Gupta, the learned counsel, appearing on behalf of the respondent numbers 1 to 6. Who's taking into account the issue involved in the instant proceedings and the requirement of disposal of the matter at the with a sense of urgency. The instant petition is taken up for disposal at this motion stage. The Northeast Frontier Railway had issued a contract tender notice for construction of additional 3 numbers of pit lines with cover shed, 4 numbers stabling lines, 2 numbers automatic washing plant building, and other miscellaneous works like construction of deep tube well, reservoirs, pipelines pipeline constructions, roads, pathways, service buildings, drains, etc. Full stop. The approximate value of the work is 1,09,03,16,436.97. And the completion period of the said work is 18 months. It is very pertinent to mention that the said notice inviting tender was issued on, what is the date?
19. Well, I'll give the date, May 24th.
Was issued in the month of May 2024. Full stop. The petitioner, along with various other bidders, duly participated in the said bid. At this stage, it is very pertinent to mention that in the said notice inviting tender, in the said, it is very pertinent to mention that to the said notice inviting tender, the GCC, the general conditions of the standard general conditions of the contract, which was made in the year, which was made sometime in the year April 2022, was made a part of the said tender documents. Clause 16.4 of the said of the general conditions of the contract stipulated as regards the performance guarantee. While subclause A of clause 16.4 related to how the procedure for the related as to how the performance, how and when the performance guarantee is required to be submitted, subclause B stipulated as to what would constitute the performance guarantee. Clauses 1 to clause 11 of subclause B of clause 16.4 of the GCC are the various instruments on the basis which would constitute the performance guarantee. Next. The petitioner herein was the successful bidder and was issued a letter of acceptance on 24/6/2024 or 24/9/2024, whereby the petitioner was asked to deposit the performance guarantee in the form as given in clause 16.4 of the GCC 2022, equivalent to 5% of the contract value amounting to rupees 3 crores 88 lakhs 80,479 rupees within 21 days from the date of issue of the letter of acceptance, valid up to the stipulated date of completion plus 60 days so that the contract agreement can be executed. It was also mentioned that a penal interest of 12% per annum shall be charged for the delay beyond 21 days, that is from the 22nd day after the date of issue of the LOA, and further if the 60th day happens to be a declared holiday in the concerned office of the railway, submission of the performance guarantee can be accepted on the next working day. It was also mentioned that in case there is a failure to submit the requisite performance guarantee after 60 days from the date of issue of the letter of acceptance, the contract shall be terminated, duly forfeiting the earnest money deposit and other dues. The mandate in which the said stipulation is the mandate, the manner in which the directions have been issued for deposit of the performance guarantee appears to be in consonance with clause 16 bracket 4 bracket A small a of the GCC 2022. It is very pertinent, however, to take note of that on the very date on which the letter of acceptance was issued, An office memorandum was issued by the Government of India, Ministry of Finance, relating to insurance security bonds, bracket ISB, as an alternative to the bank guarantee. A perusal of the same office memorandum reveals that the insurance company are offering bid and performance guarantee bonds, and they are one of the most effective ways to finance contract security options and enable ease of doing business. Under such circumstances, it was requested to explore bid and performance guarantee bonds and to adopt and promote the use of security bonds in projects related to all ministries. Full stop. The record further reveals that the National Highway Authority of India as well as the CPWD have wait, let me come. I'm coming. The record further reveals that the National Highway of India as well as the CPWD have adopted insurance security bonds as one of the forms for furnishing of the performance guarantee. A reference have also been placed before this court of a tender issued by the NF Railway, being tender number. What is the number?
This is in respect of UPC.
Huh?
UPC tender.
You have to give properly, na?
Only relevant page has been given. UPC is not engineering, procurement and construction. Engineering, procurement and construction tender. This is a guidelines for that purpose.
No, there is one, this categorically mentioned there, na? What is the number on top? 79. 79 oblique 2024 oblique
79, 0479.
Huh? 0479 oblique 0 oblique O dy dot CE oblique CON oblique F3 oblique MLG oblique NFR, wherein also in terms with clause 2.21, the insurance security bonds have been regarded, have been made a form of the performance security. Under such circumstances, the petitioners had submitted representations to the ADRM oblique Guwahati NF Railway as well as the senior DFM oblique LMG NF Railway requesting for acceptance of the insurance security bond as a form of performance guarantee in lieu of bank guarantees. No, in lieu of the other forms prescribed in clauses clauses 1 to 11, Roman 1 to 11 of clause 16 point 16.4b of the GCC. However, these representations were not answered, for which the instant writ petition has been filed. Mr. B.D. Das, the learned senior counsel appearing on behalf of the petitioner, submitted that as it is now, the mandate as per the Ministry of Finance, as per the Finance, in view of the office memorandum dated 24/9/2024, and which appears to have been accepted by the National Highway Authority of India, CPWD, as well as even by the NF Railway, the petitioner should be permitted to submit the insurance security bonds in lieu of the other forms of performance guarantee to be submitted in terms with clause 16.4b of the GCC 2022. Footstep. He further submitted that the representation which have been submitted on the various dates to the authorities of the NF Railways have also not been answered, have not also been redressed as redressed. He therefore submitted that this is a fit case where this court is required to pass an appropriate writ direction and order directing the respondent authorities to accept the insurance security bonds in lieu of the other forms mentioned in clause 16.4b of the GCC 2022. Mr. H. Gupta, on the other hand, per contra, Mr. H. Gupta, the learned counsel appearing on behalf of the respondents, submitted that though the petitioners have submitted the representations, but unless and until a decision is taken by the Ministry of Railways and the Railway Board duly notifies such decision, the petitioner would have to submit the performance guarantee in the manner stipulated in clause 16.4b of the GCC 2022. He, however, submitted that the decision may come at a later stage, but without such decision from the Railway Board, it is not permissible to accept any other form of performance guarantee other than stipulated in clause 16.4b. Isn't it, Mr. Gupta? Yes. I have heard the learned counsels appearing on behalf of the petitioners, as well as the learned counsel appearing on behalf of the respondents. The materials on record categorically show that the notice inviting tender was issued in the month of May 2024. In addition to that, to the same notice inviting tender, the GCC 2022 was made a part thereof. Clause 16.4 of the GCC 2022 categorically mandates as to how the performance guarantee is to be submitted and what is the form of the performing, what instrument forms the performance guarantee. It is, however, seen that it is the petitioner thereupon, being the successful bidder, was issued a letter of acceptance on 24/9/2024 and directing the petitioner to submit the performance guarantee in the form as stipulated in clause 16(4) of the GCC 2022. It is further relevant to take note of that on the very date, the Ministry of Finance had issued the office memorandum requesting all the ministries to accept insurance security bond. The ministry requesting all the ministries to accept insurance security bonds in lieu of as a form of as an instrument for the performance guarantee. No doubt, it further appears that the National Highway Authority of India and the CPWD authorities have already made appropriate amendments to their tender conditions. However, the railway authorities is yet to take such steps, which can only happen when the Ministry of Rail, through its Ministry of Rail, takes appropriate decision in that matter. This court also is conscious of the fact that if within the period of 60 days from the date of issue of the letter of acceptance, the performance guarantee is not submitted, it would result in termination of the contract and forfeiture of the earnest money deposit. This court is also aware of the fact that the three of the representations submitted by the petitioners are still pending. Accordingly, from the above facts, it is therefore clear that the petitioner, the last date for submission of the bank guarantee, submission of the performance guarantee in the form as prescribed in clause 16(4)(b), it would be on 25/11/2024.
24/11.
Huh?
24/11.
24 is Sunday, na?
Sunday, yes.
So it will be 25.
Next week.
On 25/11/2024, taking into account that 24/11/2024 is a Sunday. Under such circumstances, the instant writ petition, taking into account the above facts and circumstances, this court disposes of the instant writ petition with the following observations and directions. This court grants the liberty to the petitioner the petitioner is at liberty to submit the performance guarantee in any of the forms as prescribed in clause 16.4(b) of the GCC 2022 within the period on or before 25/11/2024. The respondent authorities are directed to consider the representation of the petitioners so submitted for acceptance of the insurance security bonds, and in doing so, the respondent authorities shall also duly take note of the circular of the Ministry of Railways, circular of the the office memorandum dated 24/9/2024, as well as the other circulars issued from time to time. This court further directs that in the circumstance the representation is decided to the effect that the petitioner decided on the basis of any decision from the Ministry of Railways or It is further directed that in the meantime, during the pendency of the contract, if the Ministry of Railways takes a decision for making the insurance security bonds a form of the performance guarantee, comma, the railway authority shall give the petitioner an option to submit the insurance security bond in lieu of and in lieu by taking back the performance, the instruments so submitted in terms with the in terms with clause 16(4)(b) of the GCC 2000.
They will decide the matter within a specific time.
They don't give that. The railway will come up. But if I do it, then the railway ministry won't.
Railway Ministry,
If they don't, in the meantime, they dismiss, you have to again file another writ petition. Get the point?
Malad, what I suppose, Malad, instead of Railway Ministry, your lordship may put Railway Board. Because all these matters are decided by the board.
Railway board only, every railway board only.
One or two sentences your lordship has put. Lordship may say
That is why I don't want to put a date.
within 2 weeks. if they
Because
decide.
you see, the moment he comes up, why I say that if the railway ministry comes up, immediately we get it. No? That is why I say. But if I say that within 20 days or 30 days they do it, the problem which we will face is they will reject it because the railway board had not done it. Unless railway board doesn't do it, they cannot do it. That is the mandate.
No, the only my prayer is that your lordship has already given direction to the railway board. Railway board has to decide because they said they come. Ministry of Railways in bracket railway board. Railway board. This is the letter, madam. Railway board has not taken any decision.
Now we can also direct the
Railway board is the party.
representation is okay.
The next, this year possible, decided. The railway board has to decide.
The representations are not to the railway board. And it cannot go to the railway board.
What is direction to decide whether the conduct can be accepted or not. Take a call.
What about a direction issued to the GM NF Railway to seek instructions from the railway?
Yes, that is.
I think that is the better thing. This court further directs this court further taking into account the office memorandum dated 24/9/2024 directs the general manager NF Railway to
Number three.
the respondent number 3 directs the respondent number 3 to seek appropriate instructions from the railway board as regards acceptance of as to whether the railway authority, NF Railway, can accept insurance security bonds as a form of the insurance. The said exercise be completed within 2 weeks.
Insurance security bond. Sure.
Since security bonds. I think this way you may get it.
Benefit should come. Now, many persons will be benefited. Not only you.
That is why I told you, no, sometimes you do something good for the people.
Deeply on that. 15.
But he could ready to- he could
Petitioner,
decide
is the
to-
secretary of Business mean Palak Atma Sahab. It is self-help group, my lord. The petitioner was, lease was granted to petitioner for a mohol, my lord. That is, my lord, number 12, Puni River Fishery. And it was given by order dated 9th March 2016 for 7 years. What happened, my lord? Hereafter, my lord, the COVID outbreak was there, my lord. Therefore, the petitioner could not run the fishery for several years. Thereafter, my lord, the petitioner started the fishery, but in 1920, in one installment has been given in the last year, my lord. The petitioner has been directed by Annexure 6 to pay the remaining amount. Annexure 6 page 32 was directed to pay the remaining of that year, my lord, revenue. But the petitioner thereafter by Annexure 7 submitted a representation. In the representation, the petitioner requested the authority to consider the situation and not to insist on the revenue, my lord, for the later part. Annexure 6, my lord, page 32, it is important. That is, the petitioner was directed to pay the revenue for 2019 to 2020. But one installment was paid during that year. This, as I said, my lord, the petitioner could not.
You were given for how many years?
10 years.
7 years, but for 3 years, they could not operate the fishery because of the COVID, my lord. COVID and the direction of the government. They could not operate because of the COVID, my lord.
Why?
Most of my lockdown was there and other things were there.
What lockdown was there?
Yes, my lord. Now the petitioner submitted the one application, Annexure 7, my lord. The authority may dispose of the representation considering the situation, my lord. The
What
petitioner has
situation?
mentioned about the situation.
What representation here? I've noticed that
Annexure
one
7.
depositor, it is very sad that the notice have been issued to the depositor case. The meanwhile, inequality from so and so to so and so due to the imposition of demand and the prevalence of COVID and therefore no business and resulting in notice and leadership. And notice, first of all, you should not have been at all given the contract itself. Yes, Fishery.
My lord, this is 40% fishery, my lord, this is by the DC, my lord, it has been allocated by the DC. But the representation, my lord, they stated that from 3316, when my lord is vernacular version, 3316 officer, তারিখ পর 28/2, তারিখ হলো দেখো COVID-19, 16 in there, 16
Yes,
there was
it
no
is not 16, it should be 19.
And in the English version also, my lord, 3316 to 12. So it's a COVID-19. But my lord, he paid up to 1921st installment, my lord. After that, no installment has been paid till the notice issued by the department, by the. So, my lord, and after that,
Have you been thrown out or not? Have you been removed from the fishery or not? Or are you still there?
Yeah, no, my lord, it is over. Period is over.
So you are a defaulter.
Yes, in sense.
You are a defaulter. There is no quarrel with that. You have to, there is a manner by which you can go for remission. These are aspects you can't do it.
March 23, my lord, over, my lord. Already 1 year, 6 months have already been passed, my lord. And during period, if he suffered loss, my lord, he did not represent before the authority during that period of time, my lord.
What to do? Dismiss.
I said this,
I am not in a habit of giving direction for representation
yes,
concept.
but I know it.
So you may try your luck next week. I don't give representation concept. Use the matter next week.
I know.
And 70,
Lordship, pursuant to the work order issued by the respondent authorities, I have completed all the work, my lord. And completion certificate to that effect was given by the respondent concerned, my lord. By the officials concerned, I have annexed it in annexure to page 19 to 63, your lordship. These are the completion certificates. Lordship, but as of now, they have not cleared the admitted outstanding dues amounting to 18 lakhs, my lord. They have cleared, released 24,000 earnest money as well as 1,20,000 for performance security, my lord. 19 to 63 are the lordship, the completion certificate.
The notice making is returnable on 10th of February 2025. Mr. Adhar appears on behalf of respondent numbers 1
and 3, my lord.
and 3. Pinayak appears on behalf of respondent number 2 and 4. As the respondent numbers 1 to 4 are duly represented, extra copies of the petition will be served upon them within 3 days. The petitioners herein claim that they have performed certain contractual work
Erecting or installation or either.
erection of multicolored hoardings, isn't it?
Yes, my lord. Iron frame hoardings with multicolored flexes.
Now, in some multicolored hoardings in iron frame. And against that, there is a total due of rupees 18 lakhs to which the petitioner is entitled to. It has been further submitted that only the security amount have been refunded, but the entitlement of the petitioner have not yet been paid in spite of completion certificate having been given. The respondents are directed to bring on record their stand by filing their accounts.
Lordship, security deposit as well as earnest money.
Refunded the security deposit as well as the, however, entitlement has not been.
18,
Yes. What is this?
My please, your lordship. Herein, your lordship, in one village, there are two market, your lordship. One is weekly market, another one is the daily market.
What market?
One is weekly market and another one is daily market, your lordship. And the petitioner before your lordship, they are the daily market, your lordship. We are on behalf of the daily market. And the authority used to settle both this market as a mode of weekly and as a mode of daily. Now what they are doing, your lordship, in the weekly market, they are holding daily market, your lordship. And the distance between these two market is only 1 kilometer. Therefore, your lordship have filed this.
So?
Earlier occasion, your lordship, case 31, the earlier lessee was
No, weekly market happens once.
one.
The daily market happens 7 days.
Yes.
So you are aggrieved that on one day, they should not have that weekly market.
Instead of holding one, they are holding market each and every day, your lordship.
Weekly market.
Weekly market.
Where is your representation?
Case 26, your lordship. We have made it before the deputy commissioner, chief executive officer, as well as the block development officer.
No, you are not, there is no, the authorities have not done. Somebody illegally have been doing.
Yes. Somebody means respondent number 8 to 10, your lordship. They are your lordship.
But you categorically see in your representation at page 26.
But in herein, your lordship, we have not specially mentioned about that. But if your lordship will go by the order passed in the civil court, your lordship, that is case 31.
Civil court.
Yes. In earlier occasion, your lordship, the lessee of our market, your lordship.
Civil court has passed an injunction.
Yes,
Then why are you here?
because it was in earlier occasion,
Considering
your
I was
lordship.
considering that this is a fit case to grant temporary injunction, the opposite party 1 and 2 are restrained from holding Withdrawal weekly market on every Friday and considering collecting foods they want field business.
But here in your lordship, at that time, your lordship, they, in addition to the Monday, they started to hold market one Friday.
No, but who are 1 and 2?
One and here in, I think two is here in party, your lordship.
But how is
Yes.
he running a weekly market? The weekly market is to be held under the aegis of the settlement holder. Daily market is also held under the aegis of the settlement holder. So it will be under his control and he will collect for, isn't it? Now, who have been settled with that market?
But presently, your lordship, the process of settlement has already been cancelled by the government, your lordship. And at presently, there is no any lessee in these two market, your lordship.
So there is no weekly market.
The market is going on, your lordship, but we
I am
have
asking you whether there is a settled weekly market or not.
the market, yes, weekly market has been settled as a mode of weekly market, your lordship. But present position, I am saying, your lordship, the process of settlement has already been cancelled by the government. And in place of that, the earlier lessee has been allowing, your lordship, as a mode of temporary management, your
So
lordship.
the earlier lessee who is there, is he running the weekly market?
No, he is not running the weekly market. He is not running the daily market in his market, your lordship. But more especially the respondent of
So there are 2-3 persons who are doing it.
yes,
So you have filed a suit.
the suit was filed by earlier lessee of our market, your lordship.
So now you are filing a writ petition. Why you should file a suit?
Because at that time, they,
Get an injunction there.
at that time, your lordship, they,
This has nothing to do with the government. What does the government will do? You have a dispute with somebody out there, bystanders out there, they are coming and doing some market out there. You want this court to issue a retake on them? What should this court do?
but your lordship, both this market are delivering market, your lordship, both.
The second market is being held by the lessee, the earlier lessee. He has no option. He is not agreed.
Presently, there is no any lessee, your lordship. I have presently,
So there is no weekly market.
all the tenure of the lessee has already been expired, your lordship. And in all of our ashram, your lordship, the settlement process has already been cancelled, your.
So your period is what? Over.
We are the managing committee, your lordship.
Huh?
We are the managing committee of the market, your lordship.
What business you have? You are not the lessee.
No, I am not the,
Then,
presently, what I am saying, your lordship.
then,
The present position is the market is that, your lordship, there is no any lessee. Because the lessee.
yes,
the-
madam. Madam Yudas. How these type of cases can happen, huh? Panchayat is okay. I'll ask the Panchayat. Panchayat will only seek instructions, seeing her face. It doesn't have anything. I'm asking you, what are these type of cases?
See now, madam, present.
There is no lessee. Lessee would be losing. This is some people carrying on some business in daily market and another in 1 kilometer, somebody is carrying on some business. The loss is felt actually by the government and their lessee.
Yes.
Lessee is the person. How can somebody's right to livelihood can be stopped unless the government does it in accordance with law?
Presently, your lordship.
No,
Presently, your lordship. the
petition to
petition-
be dismissed.
Lordship can issue direct to take instruction, your lordship.
No, not instruction is not required.
What I'm saying,
First of all, you have no business. You are not the lessee.
the present position.
No, you are not the lessee.
Yes.
The person you are some of the persons who must be doing business there in the market. There are some other persons who are doing business. The government has the power to regulate this market. So as of now, there is no settlement with anybody. So neither there is a, so you want your business prospects are being affected. The daily market is affected because there are some people who are also going and doing some business in the nearby 1 kilometer. You want this court to stop it? No, nothing will.
But since the,
Place for dismissal.
but
cost.
since the
How much revenue? 50,000?
revenue,
50,000, pay that revenue to the legal services. It will do good for you.
that's it, then can it be then after 1 week? You know?
No, this is
Then can it be
today
after one-
dismissed.
We are here, Lordship, because the interest of the market is under.
There's no interest of the market. Who are you to be interested in the market? You stop your business, let them
Or
do
the
the business.
illegal act of.
No,
response
first of
number
all,
eight to
why
that.
is the question of daily
We are
market or
suffering-
weekly market when there is no lessee? Let the lessee come before this court. Who are you?
But in my petition, your Lordship,
I'm
I-
come up at two.
then after
to
1
dismiss
week,
it.
your Lordship may kindly be taken.
Just think about the exact, madam, you think about what will be the exact cost.
Lordship, I am praying, your Lordship, for taking. There are 10 of my petition, your Lordship. I'll have a look for. There are 10. I'm praying for your Lordship. Instruction may be called for your Lordship.
What?
I'm praying for instruction may be called for your Lordship from the department.
For whom?
Sir, any daily market.
No instruction business. The question is only dismissal.
Then I may be allowed to do it.
You withdraw better. Counsel appearing on behalf of the petitioner submits that the petitioner would be well advised to approach the appropriate civil court, and as such, he would not like to press the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. So the withdrawal of the instant writ petition shall not prejudice the petitioners if they approach the civil court. All right.
M2,
Yes.
My instruction is that, my lord, we have not received any reference from the ERO, my lord.
We have not received
There
that.
is no case
Yes.
Your Lordship, they have been trying to locate the records. They have not been able to locate anything. We have also spoken to Gwalpara, the.
Why have you
there.
put D?
So, Your Lordship, that's what we are trying. If Your Lordship may give us a little more time to locate the records. we
No,
have been
no,
trying
the time has been given long time back.
to-
Matter has been going on all from 11. Does it take a time?
So, Your Lordship, in that case, you may dispose of the matter in the terms of Safia Begum versus Union of India. There was a,
What does it say?
yes, Your Lordship.
It has been made D.
Yes, Your Lordship. Actually, what must have happened, that's what the Deputy Election Commissioner who spoke to me a little while back said that in 2005, a lot of people were marked D voters, and then there were most of the cases went to the Foreigners Tribunal um, for further inquiry.
Where is the D marked, Mr.
And D Millard, 2011 Millard,
Page?
2005. The petition says 2005. Your Lordship.
and 11
Page.
also Millard. 5,
Which is the voters list for the D?
his brother Millard, page 18 and page 20. And Millard, page page 16 also Millard. Starting from 16, D has been put Millard.
Your
And
Lordship,
what about the recent voters list?
Central, the
Why haven't you brought on the recent voters list?
I asked Millard, but he said all are having a D voter and he has no photo is in the Millard voter list. Only name is there and D is put in the left side. His-
Where are those?
But I keep not collecting Millard.
Why?
There is,
There is some
oh, it's a community.
problems.
No other problem is there, Millard.
Then why haven't you collected those? Isn't that required that you have been continuously shown as the voters?
I will collect all this.
Notice making it returnable on 5th of February 2024. 25. None appears on behalf of the Union of India. The J. Payang appears on behalf of the respondent number 2 and 4. The S.R. Borua appears on behalf. You are appearing. One appears on behalf of Ms. B. Sharma appears on behalf of the Union of India. The J. Payang appears for respondent number 2 and 4. Mr. Kush Das appears on behalf of the respondent number 3. And 2, 4, and 6 take J. Payang. And Mr. P. Borua appears for the respondent number 5 and 7. As all the respondents are duly represented, extra copies of the petition be served within 3 days. The petitioner herein is aggrieved by the marking of the letter D against his name in the voters list of LAC 39, also in the voters list of 2011 pertaining to LAC number 39, Zolsar, village Soral Jar. It has been submitted by the learned counsel appearing on behalf of the petitioner that since 2011, in each and every voters list, the petitioner's name has been marked with the letter D. Enquiries were made with the authorities concerned, and the superintendent of police B had also informed the electoral registration officer that as per their records, there is no FT/D voter case found against the petitioner. It is under such circumstances, the petitioner has approached this court for removal of the name letter D, in as much as the same have been made without following the due process. The respondents are directed to bring on record their stand by filing their affidavits on or before the next date. Pendency of the instant writ petition shall not be a bar upon the concerned respondents to refer the name of the petitioner to the foreigners tribunal, if not referred till date, and the petitioner be informed about such reference.
Item 69, fixed at 2 p.m.
Made please. In terms of the earlier order, Your Lordship, we have taken steps for paper publication along with an application also.
Yes, what is your case? You have filed a paper publication
Yeah.
application?
On
Yeah.
18th,
It has not come?
it is there in file 2, I think.
Huh?
The second file it is there. The second file it is there.
What have you done? Have you filed an application for paper publication or not?
By an application, Your Lordship.
Absolutely. Have you done or not?
Lordship, I have filed an application also.
No, the office note says that you have not filed. You have filed only given a step. That won't do. There has to be a direction for paper publication.
On the
No, this is a step.
the first page, there is an application also. Handwritten application. Very good.
How many years of practice you are having? Huh? How many years?
10 years.
10 years you don't know that for paper publication you will need an order from the court. And if the order of the court has to be there, so accordingly, what did I say? The application be filed for paper publication by 1811. It was not filed. So we will strike out your name of the respondent number 27. Yes, what is your case?
It was petitioners, Your Lordship, they are the villagers of one Pandra, village situated in the Kachar district. It's a very small village, Your Lordship. In this village, Your Lordship, during the period from 2011-12, approximately about 22 number of industries, stone crusher, iron melting crusher industries were set up. And this has resulted in a severe degradation of the locality and causing health hazards as well as causing problem for the agricultural lands also. And all these industries, Your Lordship, they were built up on agricultural land and nearby the agricultural land within a radius of 3 kilometers. Almost some 22 industries, and recently some other industries have also grown up in the meantime. There is a Madura quarry nearby, Your Lordship. Stones are available. So all these industries have come up in this area, Your Lordship.
Huh?
There is a Madura quarry where there is availability of stones. As a result, all these industries have been set up in this village, Your Lordship.
Then?
Whether so when the process was initiated, when starting of this, the petitioners along with local villagers also, they have protested that such number of industries should not be allowed in a single place. But the Lordship, all they have received the necessary permissions and have set up the industries.
Then,
We approached way back in 2014, your lordship.
what does the pollution control board say? Who appears for pollution? Yes, Mr. Hezbollah, you are the main person.
We have filed our affidavit, so affidavit is clear with all the reports that we have gone through. So this affidavit says that out of 21 number of industries, accorded permission to 13 number of industries. And this air quality monitoring and all those parameters have been checked. They are found to be in norm.
They have
They're found to be under the permissible limit.
all these industries.
Yes. So as regard the pollution aspect, we have given the
Status of
report.
the
So the
consent,
report is also part of my affidavit. as
ordered
next
up to Iman, so and so. So everybody has been, now these, what about the Star Brick Industries? They closed down?
Yes,
Huh?
out of these,
Public industry, I think they have.
the present status of the industries, I have given a list last time.
I've got it.
Out of which, some 2 or 3 have been closed.
These
Because
two
they are
have
not
closed down.
They're-
Simplex
They're not
and Star
functional.
Bricks, they
Yes.
closed down.
Yes,
Closed after completion of the contractual. So these two are closed. So others. 11, what has happened? The then president of AR remarks, what is this? Huh? So he has nothing to do. And 12 has the, what about 12? BM Stone Crusher?
Well, they have already filed their affidavit.
What do they say? Who is paying for 12? What, do you have the permission? You have the permission here? You have the consent or not?
we have filed affidavit, my lord.
I'm not asking, I'm asking you a simple question, Mister.
Yes, ma'am. Consent is done.
Till,
My lord, I enforced consent letter 19/9/2019.
then now do you have the consent or not?
But it is renewed time to time, my lord.
Then,
Moreover, my lord, we have taken a ground in this, my lord, affidavit, that the repetition itself is not maintainable on the ground, my lord, that my lord. He has, my lord, the petitioner has appended certain medical documents along with certain representation to the deputy commissioner. That the medical document and the representation, this does not belong to him. He has not signed any representation and the medical certificate issued to others about the deformity or suffering caused. So, my lord, we have taken the ground, he does not have locus standi to file the writ petition because this is not a public interest litigation. He is not a affected party, therefore, this perhaps, my lord, maybe dismissed, my lord. Because,
don't worry, we dismiss this petition on the ground of locus.
my lord,
Then we'll direct the registry to restore it as a suo motu writ petition. Don't worry with that. Now come to the point.
my lord,
It is a case of environmental pollution.
just correct.
That this court can't shut its eyes.
And-
come to the point. Do you have a permission or not?
We have, here, my, I appear for response number 12, 13, 15, 17, 19 and 28. And we have enclosed, my lord, the consent letters. From the
That is of the year 2019.
Aye.
What about now?
My lord, because it was filed one earlier, my lord, the latest one, we have not, this is filed November 2020, my lord.
You are appearing for 12.
12, 13,
13 has
yes,
till
have-
2024-25.
yes,
Then
15, my lord,
15 also has.
yes, 18, my lord,
18 also has.
19, my lord,
19 I don't know.
and 20.
20 has. 19 I don't know. But the Pollution Control Board, if they don't have a consent, every year they have to renew the consent. If they don't renew the consent, what do you do?
They have to automatically close down because ultimately they are not authorized to function without a consent. And necessarily, it's not that every year, sometime it happens that the consent is given for a term period of 3 years, maybe of 5 years. It depends upon the decision of the board. So ultimately, they have to show that this consent is surviving.
Because your document out here does not show in respect of all. It shows a few.
And in my affidavit also, out of 21, 13 consent have been granted, and out of which 2 have been closed down. So
Two have been closed down, those two, 31 and 32. They have closed down. Now, as regards the others, you say 1, 2, 3, 4, 5, 6, 7, 8, 9. You have only mentioned about 9. What about the others?
I think those consent they haven't applied because ultimately we are giving this report based on the office records. That's
Okay, we do one thing. We ask the state as well as you to give us an updated status of all these as to whether they are running,
the units which are part of this petition.
as to whether they are running, and if they are running, do they have the consent?
Yes.
This is the two things.
That is good.
If they have the consent, we have no business to look into it because the Pollution Control Board has duly taken note of. Yes.
14 and 17 are concerned. We have the next concern after 25. 14 and 17.
14 is not here. 14 is not. 17 is there. ABC.
14 and 17.
ABC.
APC, I realize my lord, Nidhi.
ABC is there and 14 is progressive.
So the consent, I have a next color after 25.
Okay. But anyways, let us get the updated instructions and then we close this petition. The petitioner is not interested out there. Unnecessary, why should we do this? The petitioners herein have approached this court seeking appropriate directions upon the respondent authorities to take action against the respondent numbers 12 to 32. As they have been running the said businesses of stone crusher without and illegally and in violation to the provisions of the Air Bracket Prevention and Control of Pollution Bracket Clause Act 1981. Full stop. From the materials on record, it reveals that the Pollution Control Board have granted the consent to various private respondents, which is valid up for the period from 2024-25. It is further seen from the materials on record that as regards the respondent number 31 and 32, they have closed their units. Under such circumstances, this court directs the Pollution Control Board to provide an updated status as regards the private respondents hearing as to who are functioning and as to whether they are functioning after obtaining the necessary consent. List this matter again on 16th of December 2024. The affidavit be filed by the Pollution Control Board on or before the next date. This court further strikes out the name of the respondent number 27 from the array of parties, taking into account that the petitioner have failed to take steps against the respondent number 27 in spite of various opportunities. The registry shall make necessary correction in the cause title. The petitioner herein is directed to also file a fresh memo of parties in view of the order so passed.
On item 66.
Yes, where is missing? What are you doing? Why you are still continuing in spite of the order passed by this court? that you will do this?
Earlier. Your lordship,
Now, is it running, this one?
no, my lord, the lordship has passed this order, my lord.
My order is of 28.
Yes.
But is this running?
2906.
The settlement of Mill Mahal, is it running? How are you running it? When you have no business on.
settlement order is issued, my lord, in the 29/6/2024, earlier, my lord. The order is August.
Understood? It is in consonance to this period, na? Hello? You have got that judgment of mine?
Yes, my lord, it is a very, yes, I'm giving my lord.
WBC 3065/23.
We state
It
this
it is
immediately.
very clear, my lord, the missing autonomous council has no authority and they cannot do it. So, my lord, is the allotment, this, that should go.
We should notice, because there is a private respondent, no? Without hearing him, it would not be proper. Although he has no right, but then also, how can I do that? We state immediately and direct them not to further, direct them to enforce it. You should notice making it returnable on 16th of December 2024. Miss S. Yeah. Fishery? No fishery. None appears on behalf of the Fishery Department of the Government of Assam as well as also for the Assam Fisheries Development Corporation Limited on call. Your name? Igogoi appears on behalf of the respondent number 45, Miss Yudas. The learned additional senior government advocate appears on behalf of the respondent number 6 and 7, 6, 7 and 9. Pusto. Taking into account that the respondent numbers 1 to taking into account that the respondent numbers 4 to 7 and 9 are duly represented, extra copies of the petition be served upon them, upon the learned councils during the course of the day. As regards the respondent number 1, 2, and 3, the petitioner is directed to serve copies upon Mr. P. Sharma, the learned standing counsel of both the Fishery Department as well as the Assam Fisheries Development Corporation Limited. As regards the respondent number within 3 days, during the course of the day. As regards the respondent number 8, the petitioner is directed to take steps by way of registered as well as usual. In addition to that, the petitioner is also directed to effect service by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner is a settlement holder of which one? Settlement holder of
Annexer 2. Horizontally main piece.
Huh?
Annexure two, page 44.
Of Arjan Bhuli Min Mahal,
In Madhya district.
which was settled with the petitioner by an order dated 16/7/2021 for a period of 7 years. 7 years?
Yes, my lord.
Full stop. Be that as it may, the respondent authorities, the respondent number 4 had initiated a tender process. And settled some portion of the said area falling within the settled fishery of the petitioner to the respondent number 8 by an order dated 26/9/2024.
29/6.
29/6/2024. It is the case of the petitioner that the said action could not have been taken by the respondent number 4 to 6. To 4 and 5, taking into account that the missing autonomous council has no authority or jurisdiction to settle any fishery, any water body. The learned council referred to the judgment of this court, the case of Dibrugarh Fishery Cooperative Society Limited versus State of Assam, dated 28/2024, whereby this court had categorically held that the missing autonomous council had no authority to make settlement of the fisheries in question, any fishery or even natural water bodies, in view of the notification dated 7/3/2017. Taking into account that the matter, the issue involved in the instant case is squarely covered by the decision of this court in the case of Dibrugarh Fishery Cooperative Society Limited Supra. This court directs the stays the settlement made in favor of the respondent number 988, dated 29/6/2024. Further to that, the respondent number 4 and 5 are directed to forthwith direct the respondent number 6 not to carry out any further fishing activity within.
Number 8.
That is what I'm asking him to direct.
My lord.
You want to dictate?
No, my lord.
You want to dictate? You
Sorry,
can
sorry.
direct the respondent number 4 and 5. But this court further directs the respondent number 4 and 5 to forthwith direct the respondent number 8 not to carry out any further fishing activity on the basis of the order dated 29/6/2024.
My lord, my prayer is, my lord, the steps may be taken within 2 days, my lord. It is within the day, it is mentioned as within the day. I will take these steps within 2 days.
So after then, I'm not passing an interim order. Okay.
No,
You-
my lord.
Do it after 3 days.
No, my lord. Within
No
2 days, my lord.
interim.
Within 5 days, my lord.
Sorry,
Okay, my lord.
you have to take these steps during the course of the day. You are getting an interim order, it is bounden duty, you have to
Yes,
take it.
fine.
7.
The.
Where is this?
6.
For that matter? Okay.
I'm coming with my lord.
Lordship sought them to my lord, submit a affidavit in respect of the permission issue, and second, my lord, about the application of 337 for part one.
Peter has a one and two notices. Open notice has been issued. Now final call has not been taken. However, the reply has been there. In the meantime, he takes out a permission.
No, but Mr. Samaria, till date there is no order passed.
But the thing is that the 337, 1 and 2 itself clearly indicates that 7 days they will take action, my lord. 337 notice which they have issued to us, where it is clearly mentioned that within 7 days they will take action in absence of, my lord, whatever their dissatisfaction. Then on that ground, my lord, suppose immediately they rush to our.
You have submitted your reply on 4/11.
Yes, my lord.
4/11, 4/11,
411.
Yes,
they have not decided till now.
exactly, my lord.
Why should this court be
That's why,
judged?
my lord, lordship kindly see for a moment that the earlier occasion while we have filed this petition, my lord, reason behind that, lordship kindly see the notice.
We can very well say, taking into
Lordship
account,
kindly see for a moment-
they have not decided, taken any decision till now. Why should we pass an interim order?
my lord, kindly see that page 39 for a moment, page 39.
I remember the case.
Yes, but no, not required. Now, lordship, kindly see that they have mentioned two things, my lord, about deviation part only, my lord. It is not a case the entire construction is also, one bigger, 1 kata 10 lesser permission they have already granted. Now, 5 lessers, my lord, that construction are in question, my lord. Therefore, my lord, whenever we carry out the construction, we will adjust and thereafter they will the field verification, my lord. If any violation or whatever, they will not issue us the occupancy certificate, that provision is there, my lord.
No, why should this court now interfere?
But question is that, my lord, there is a heavy apprehension, my lord, because
What is the heavy
well,
apprehension?
kindly say, that clearly said, if you do not submit any explanation as demanded above, if the explanation submitted is found unsatisfactory, the Guwahati Municipal Corporation will be free to proceed under section 337(3) to deal the unauthorized construction and mention in schedule, my lord. So therefore, my lord, suppose immediately they will take a action, my lord, we don't know anything because their action, lordship, kindly see, even my lord, there is a stay order was there. Even that, my lord, they have issued this
No, no.
notice.
If they pass an order, thereafter give you 7 days and then take it.
My lord,
That
Let
lordship,
that
decision is
Lordship-
taken, that will be executed after 7 days.
lordship, can
Huh?
Any decision is taken,
After
will be
7
executed
days,
after 7 days.
from the date of intimation.
Lordship, can it be done this way, my lord? Our representation is there, a hearing may be given to us, my lord, because a hearing may be given to us, my lord. Thereafter, they will pass our order and give us a copy, my lord, so that, my lord, we can take our request. But
Then if you are nowhere to be found, to be served a copy, then how does it happen? Huh? That is also big issue.
lordship,
You have to appoint somebody.
we leave it to
So
lordship, we leave it to lordship wisdom. We need protection simply.
No, in one case, I have directed, therefore, they will put it on the notice board itself as to where the order to be. And then from there, 30 days I will be.
Now, lordship, I leave it to your lordship wisdom. We need protection, and no, lordship, in what manner, lordship, we will be protected. We leave to your lordship. My lord,
No, they can serve.
examination.
That 330, after that, the notes, the so
No,
notice is
you
there,
do
they
one
reply-
thing, you decide this.
Decide, then
Decide this and give you an opportunity of hearing whatever Mr. Samaria wants to go there and say in a old office we have used to represent. And thereupon you decide, and thereupon give them 7 days time.
they, while let the commissioner decide. They think get another 7 days. Thereafter, if he is unsatisfied, he 438 appeal is also provision is also there. They can go
We'll
for
see
it.
then.
They
That is
change
also
the, they change the route.
What is the period of appeal?
Well,
Period of appeal is what?
my lord,
the
there
date
is
of the order, 30.
45 days,
30 days.
30 days.
30 days you don't do. Appeal is provided. That is what the Supreme Court says.
Lordship, the thing is that why they're running about this small, my lord, portion of building, I don't know, my lord, because only one person
No,
against us.
they don't like you. That must be the reason.
Lordship, I leave it to your lordship.
No, I think for this court now to interfere would be portraying a wrong signal. I'm not going to do that. Because you see, you filed an IA at that point of time, taking into account this.
Well.
Whenever, but one very important aspect is that 337 was issued on the basis of you could not submit any NOC pursuant to the direction issued by the associate planner.
Right. Right.
But thereafter, you have brought in the permission,
Right.
which was given on 4/11.
Right.
So there has been no decision thereafter. So under such circumstances, when the matter is in session of the commissioner, this court should not now.
Lordship,
Because otherwise it will, you see, entertaining these type of matters, one means you will be opening the Pandora's
floodgate, my lord.
floodgates.
But Lordship, this notice carries the background of that earlier, my lord, the 13/5/2024 notice. That's why, my lord, if it is independent, my lord, suppose it's a.
That is why you replied. They have to now take into account your reply
Exactly.
with that 2910, however you got it.
Yes.
On 17, he got a permission, my lord.
Huh?
He took out a permission also.
Yes, that is what.
That's so.
Where we will
Everything
go, I
is
don't
very-
know,
very-
but we are
very-
running from
everything
here
is
to
taken
there.
back.
Heard Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner, and Mr. S. Bora, the learned counsel appearing
All
on
right.
behalf of the GMC authorities. The petitioner herein have approached this court assailing the notice dated
It's 39.
Page 39, madam.
29/10/2024, issued by the Commissioner, Guwahati Municipal Corporation, pursuant to the leave granted to the petitioner in the order dated 13/11/2024, passed in I civil number 3373/2024, arising out of WPC number 2790/2024. From the facts, from the materials and report, it transpires that the petitioner was issued a notice, was initially issued a notice on 13/5/2024 by the associate planner, isn't it?
My lord. No, assistant associate planner.
Assistant associate planner, asking the petitioner to place the no objection certificate. Full stop. The petitioner challenging the jurisdiction of the associate planner, assistant associate planner, had filed the writ petition being WPC number 2790/2024. While the said writ petition was pending, the notice was issued on 29/10/2024. No, full stop. Prior to, no, full stop. During the pendency of the writ petition, the petitioner obtained a permission, a no objection certificate for construction on 7/10/2024. Be it as it may, without taking notice of this permission obtained on 7/10/2024, a notice was issued on 29/10/2024 on the ground that the petitioner failed to submit any no objection certificate as well as the approved plan pursuant to the letter dated 13/5/2024. It is further seen that the petitioner had submitted a reply on 4/11/2024, stating inter alia that the petitioner now has the permission dated 7/10/2024. In addition to that, it is the specific case of the petitioner that in view of section 337(4) of the GMC Act 1971, for short, the Act of 1971, the proceedings under section 337 cannot be initiated in as much as the petitioner has a no objection certificate as well as the approved plan. Be it as it may, this aspect was brought to the notice of the Commissioner GMC by the reply on 4/11/2024, and the Commissioner GMC is still in session of the said proceedings. Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner submits that the petitioner taking into consideration the manner in which the GMC authorities are after the petitioner apprehends that any day an order would be passed under 337.3 and thereupon the petitioner's building would be demolished. He further submitted that the petitioner should be afforded a personal hearing before passing such order. Mr. Elbora, the learned counsel appearing on behalf of the GMC authority, submits that the commissioner have not passed any order pursuant to the reply submitted on 4/11/2024. He submitted that at this stage, the question of interference by this court ought not to be made, taking into account that the matter is still pending before the Commissioner GMC. He further submitted that Commissioner GMC shall take due action as per law. Taking into account the above submissions, this court is of the opinion that as the Commissioner GMC is still in session of the matter, it would not be proper on the part of this court to take up this instant writ proceedings, entertain this proceedings at this stage. However, it is also, this court cannot also be unmindful of the apprehension of the petitioner. Accordingly, this court disposes of the instant writ petition at this motion stage itself with the following observations and directions. Number one, the Commissioner GMC shall afford an opportunity of hearing to the petitioner by fixing a particular date and time. Before passing any order pursuant to the notice dated 29/10/2024. Number two, this court further directs, taking into account the recent Supreme Court judgment in the case of Demolition, reported in 2024 SCC Online SC. Itu dimulai di sini tama. Directions in the matter of demolition of structures reported in 2024 SCC Online SC 3291 directs that for a period of 15 days from the date of service of the order upon the petitioner, no actions be taken if any order is passed under section 337(3).
Only one line, after passing of that, we will be allowed to take legal recourse, because appeal provision is there,
That
suppose.
why not I should say that I should draft the writ petition also for you? My goodness, 15 days is for
We
that
are apprehending
purpose.
a lot from them, we don't know what.
I've given you 15 days, you know what to do.
Right, this is an item 19 and 20.
Yeah, please, Your Lordship. I'm praying for adjournment, Lordship, as my senior is out of station. Lordship.
What is this?
Lordship,
Oh, this one. You filed that thing. So I asked you to bring the records.
Yes, Lordship. Lordship, the records are in possession of the bench chairman. The records which your Lordship saw, those are in possession of the bench chairman, answer are the same. So we have filed an FIR against them.
And how do you say that there is nothing on it? How is it? How do I say that there was nothing? You say that there was, you shall obtain this one, Mr. Arbora, the learned government hearing on the shall obtain the Sopor Municipal Board on behalf of is directed to produce the minute book of that period to ascertain as to whether there exists in board's authorization to the chairman to make allotment as have been purportedly done in the instance.
Yes, we tried to find it out in our office, we could not find it. We have examined certain employees also in respect of that to find out whether those are in the office. We could not find it out. In fact, there are statements of the employees where said that those resolutions which your lordship has sought are in the possession of the bench chairman. So we.
How
tried-
is he still holding it? Is it his
Lordship, we
parental
we also
property?
called him, we tried to investigate into the aspect. However, he is not cooperating with that issue, and yesterday we lost an FIR for the officer in charge of Police Station. Lordship.
He's enjoying a stay
Yes, Lordship, from 2020.
and he's staying there.
Lordship.
What stay is it?
Lordship.
What is the stay?
The notification writing tender for state. Lordship.
Oh, now is he in occupation
No,
and you are losing?
no.
You are losing revenue.
No, no, we are not, we cannot use that because of the stay order. Lordship.
You are losing revenue.
Yes, yes, we are losing that.
And how many shops you are?
Total 7 numbers.
And how many petitioners are here?
4.
4 petitioners.
Yes, at number 19.
And everybody has got 25 years.
Yes.
Huh?
Yes. And in fact, in petition number 19, if your lordship peruses the case for a moment, here petition number 1 had applied for the against the notification, and then petitioner number 1 was allotted the room, and then petitioner number 1 and 2 they entered into an agreement because of the financial difficulty of the petitioner number 1. Petitioner number 2 entered into an agreement with the then chairman, whereby they are claiming their right. And now petitioner number 1 and 2, both of them are before this court, saying that both have that locus to find the writ.
And what about the second one?
Second one, if your lordship, and one surprising and shocking thing came to my notice, lordship. This allotment order, if your lordship peruses that 25/11/2018, it was a Sunday, lordship. 25/11/2018. So what is shocking for me, which municipal board remains open on Sunday?
I think we should send these 2 persons along with their counsel also, no? For 340 investigation. 340 investigation against you. Why you are making false? Somebody has certified it to be true copy, na? Who has done it? No, certified to be true copy in the court. Who has done that? Some lawyer has done it.
All the documents are
Who has brought it? Certified to be true copy.
as per allotment order is all.
Where about that? Who has? Yes, some Raza. Whose name is this?
My name is.
Oh, hello. You have certified fraudulent documents.
All the documents are.
How is it possible? 25/11.
Yes, that it was a Sunday. I tried to check it.
25 not lordship, 26/10.
Huh?
26/10.
But that was the notice issuing tender.
Tender notice was
the-
issued, lordship. As
and
per
the
tender
allotment order.
notice,
And the notice inviting tender is,
Page, your lordship may.
Page 18.
Yes, page 18 is the tender allotment order.
we have been selected for allotment of
Yes.
area.
The date is 25.
1 lakh. Second level installment is 1 lakh. And you have entered into an agreement for 20 years. How many years?
25 years. Serial number.
This is on the face of it illegal.
And that agreement was signed by the elder son of the then chairman.
lordship. Petitioners that are public, lordship, they applied for the allotment of road. As per-
And he has taken advantage of this fact, na?
as per
There's
appli-
only a certificate by which this
They
petition
have
was filed.
submitted the bank draft also.
And there is no reply also filed.
As per application, they
You
have.
file
given-
reply. So we catch hold of him only. There is no affidavit. So 340 won't come. That is why they have filed it.
Lordship, kindly adjourn for today, lordship, my senior may be.
No, nothing doing.
Lordship for
We hold
tomorrow,
you.
lordship.
There's an affidavit also. Who has filed it? Sokumuddin Sheikh. Who is he?
He is the petitioner
Petition
number
number 2,
2.
lordship. He entered into
He
agreement.
And
entered
what about the other matter?
The issues are same. Lordship. The facts are similar.
All 25 years.
Yes, all 25 years. And all the signatories to the contract, which is not even binding.
But I have not extended the interim order.
In that case, we will proceed with the new fresh tender.
On 6/11, I did not extend it.
In that case, we will proceed with fresh tender, lordship. If your lordship allows, then we will proceed with.
Yes, yes, you go ahead. Editor order লিখিব দেই।
Lordship, kindly adjourn for today, lordship. Tomorrow.
What?
Tomorrow may be fixed, lordship.
What?
Tomorrow may be fixed, lordship, as per.
Tomorrow,
Yes, lordship.
5:30. 5:30. I give time, 5:30.
Lordship, my senior is out of station, that's.
5:30 tomorrow. Evening. My matter finishes at 5 o'clock, so I'll give you time.
As per convenience of the court.
I'm always at convenience. Your convenience is better. This matters again on the counsel appearing on behalf of the petitioner have sought for an accommodation. Also, the matter has been authored before this court. No, this court have also inquired with Mr. Arbora, who were asked to produce the minute book for the period, to ascertain as to whether there existed any board authorization to the chairman to make allotment, as he has purportedly done in the instant case. The learned counsel, government advocate, submits that the then chairman has the custody of the said documents, and as such an FIR had to be filed on the date 19/11/2024. Accordingly, this matter again 17th of December 2024. It is further mentioned that this court is not extending the interim orders.
Lordship, I'm not government advocate. Lordship has written government advocate. I'm not government advocate.
You are what advocate?
I'm appearing for the respondent for it. Online.
Yes, NHAI?
And now we have to pay after the reassessment, 2,28,669.
How much?
2,28,000, 669.
Valuation of building, 260. Difference, already they have paid some
Reassessment,
amount.
after the reassessment.
Additionally, another 2 lakhs. When are you paying?
So we'll pay lordship. We'll pay lordship, the
When?
remaining amount. We have to take sanction from the headquarters.
If you don't pay, interest will be there, na?
It's the building estimate.
Understood. This amount will also carry interest. Don't you think that?
Because lordship, we are not aware of this assessment. report
Understood.
because they
So,
have-
so
they have
under
given
such
the-
circumstances,
all these-
if you keep on
during the-
delaying,
Pendency of the case, lordship. They have supplied all these documents. When I wrote the department lordship regarding the case, the ADC, they have given all these documents after that lordship.
Arbora, the learned standing council of the National Highway Authority of India, submits that pursuant to the assessment so made, the NHAI is now required to pay an amount of rupees 2 lakhs
28,000.
28,669.
669. He submits that the
That
matter
was
has been placed before the NHAI authority and would be paid within a short time. To establish this matter again on 16th of December 2024 for an update. In the meantime, the NHAI authority shall take appropriate steps for disbursing of the same.
22.
But this method relates to the petitioners.
Oh, this one,
Yes, my lord, the Panbajar.
where is the education department?
That the report of the inspector of schools.
Oh, you don't have a case here.
My lord, ultimately, my lord, what happened during the period, the proper,
No
the.
case of having any shop within educational institution.
So we Lordship kindly turn to Lordship.
I am not going to look into any.
Otherwise,
You
my lord, it's a
cannot.
matter of life and livelihood, my lord, of the
So
people.
what? There's no question of livelihood to have it within the educational compass.
Not within Lordship. That's what I wanted to project your Lordship. My lord, Lordship kindly turn for a moment, page 20. The annexer P, it is an agreement of the managing committee with the petitioner number 3. Lordship kindly turn the next page, page 21.
Kindly come to page 24. One big room measuring about 10 to 20, that is 200 square feet with first floor structure situated on the first portion of the institution facing the 80 road. What is this?
Lordship kindly, that's what, my lord. I'm good. Page 21 for a moment, my lord. Page 21. It's a part of, it starts at page 20. Page 21.
Yes.
It starts of a place in the Palkan Bazaar area for carrying on business, etc., and voluntarily appeared before the first party has requested the first party to let out the place of business proposes situated outside the campus of the first party school building.
To let out a place for the business purpose situated outside the campus of the first party school building, which is more specifically reflected. Detailed report. What is the date of this document? Madam, what is the date of this document? Why you are placing the same document every time?
Your Lordship, that is the only document I have received, Your Lordship. Already detailed report in this connection is going to be prepared, Your Lordship, by the inspector of the school.
But why you are submitting the same document? Does it take such a long time? You submitted this very document on 39. Happily, I remember that. Why you are submitting? It seems that these people are not concerned. Let's hear from the director of secondary education why the report has not yet been prepared.
They are preparing
You
it,
seem
Your
to be in
Lordship.
hand in
Already
glove with the petitioner.
yesterday, Your Lordship, I made communication, Your Lordship. They told me that one reporter is preparing, Your Lordship, in this.
How
regard,
how
Your
long
Lordship.
does it take?
Your Lordship,
They are to go there and just verify whether it is inside or outside.
it is inside the premises.
Where is it said?
Your Lordship, I need to take that written instruction, Your Lordship.
What?
Short date may be given, Your Lordship.
Tomorrow. The instructions of court by the order dated 39/2024 have not been placed before this court. Pusto. Ms. Pida submits that a short date may be given. Accordingly, list this matter on 25/11/2024, on which date the Director of Secondary Education shall ensure that the report be placed before this court without fail.
Interim order is there.
No interim order.
There is already an interim
24.
order operating.
Mr. These 2 days you leave without that because the 25th I'm dismissing your petition. Ask your client to get ready.
24.
I have filed the affidavit.
You filed the affidavit.
Yes, madam. In fact, on that very day, madam, there was a communication addressed to me,
Ah.
stating the same text that I have annexed.
That
was
affidavit
filed
is not
yesterday,
on
madam.
record. When did you file?
Yesterday, they have
Yesterday.
filed, right? They have
Huh?
received the copy yesterday.
Yesterday, madam. Yesterday.
Okay. Mr. D. Gogoi, the Standing Counsel of the Forest Department submits that the affidavit has been filed. Full stop. List this matter again on 9th of December. In the meantime, the petitioner, if so advised, will be at liberty to file the reply. The registry shall bring on record the said affidavit.
25.
The undisputed amount has been released as per order dated 27/6/2024, my lord. Whereas the interest part has not been paid till date, my lord. as per instruction by the department, my lord, this department is going to file IF to waive off the interest part, my lord.
Huh?
Interest part, my lord, that is 9% interest.
We got the main amount.
Minimum.
Now we are concerned with the interest.
No, lordship, there are two parts. One is disputed amount, one is undisputed amount. By the order dated 27th of June, the undisputed amount
Amount has
was
been released.
directed to be released with interest at the rate of 9%, lordship.
Shall submit within 7 days from today to the respondent a fee receipt for the amount of 2 lakh, and on receipt of the said amount received, respondent shall release the amount involved to the petitioner herein within a period of 15 days thereafter, along with an interest rate of the rate of 9% from the date that the amount was paid.
So that principal amount has been released.
So you got 2,03,000,
Yes, he released
but you have not received the interest.
interest.
How much it is?
Interest from 28th of February 2013. Lordship. Till release. It will be around 2 lakhs.
But how do you say that the interest is within 15 days thereafter, along with interest at the rate of 9% per annum? From the date the said amount was so paid.
There are the IA also, they
There was-
file IA for classic
Clarification of
date
the-
of interest shall be calculated.
Then what has been
IA
made?
number 2617.
Then what has happened?
And 28 to 2013. Interest. Rate of sanction.
Order dated.
Accordingly, respondent will now calculate the interest so payable from is the same as the earlier. However, the interest so calculated is there. So the interest will be from 28 to 2013
That is,
at 9%. Why the 9%?
my lord, it is up to the lordship, my lord. Lordship is,
Now the interest has not been paid.
yes,
Okay, when are you paying?
as per instruction, my lord, they are interested to file IA to waive off the interest, my lord. To waive off the interest claim. by IA. As per instruction by the department.
But then you have not filed the IA.
I'm going to file, my just yesterday I have received.
The pursuant to the legal counsel appearing on behalf of the respondent submits that pursuant to the order passed by this court on 2/9/2024 in I Civil 2617/2024, the respondents are you have to file a review, not an IA.
Very good, my lord. Review.
Are contemplating of filing a review to the said order. He therefore seeks 2 weeks' time in that regard. This matter after 2 weeks.
And then I have to send to Delhi of disbursing officer. They
You
have-
are going to file a review. Review is, don't require an affidavit.
26.
Public.
What is this?
Lordship, as per your lordship's order dated 21/8, there was a special query being raised regarding whether this compensation amount has been paid or not. But in this case, we are not much concerned about the compensation amount, but the pipeline passing just through my house, there is not permission under the act. That is the case. Compensation are bound by otherwise.
No, what is your case, Mr.?
My case is, my lord, I have a residential house. And also a godown is being constructed just attached to my residence. Just near my house, the pipeline is drawn. And there will be four pipelines going through that route. ONGC, oil, mineral corporation, others. So there is not permissible residential area pipeline cannot pass through. And there is the, under section 7 of the Act of 1962. There is my case. Not the matter of compensation. I have not come for compensation. Compensation authorized also, they are bound to pay if I lose the case. So there is people, sir. I think. People, sir.
So you want the setting aside of those notifications
Yes. So, Malad,
on the ground?
on the ground of section 7 and 9 of the Act. Which is special for me, for immediate. They say, since in my application objection, I had mentioned.
But what
that-
has happened now? There is no stay.
There is no stay in this case, Lord.
Then what has happened?
And the pipeline has already been laid. Otherwise, the issues.
It's barred by law, man. Still barred by law, then pipeline, laying wood, a pipeline would not matter.
Hmm?
It is in the national interest. Otherwise. And the pipelines all over the state.
National interest, of course, but surviving of a person is also necessary. There is a blast,
Otherwise,
malad,
we are
many
not
houses.
acquiring the land,
Any leakage or blast.
only the right of.
Huh?
Only the right of. use of-
Right of use. Then
Otherwise, we are not acquiring the whole land. Only the pipelines will be laid from inside the ground. And above the soil, we will have the whole, liberty to use the land.
so he can
Only,
construct above.
only constructions, we cannot lay.
What is he going to do with the land?
Whatever other activities.
What? Grow crops? No, tell me, something is there. Then. So your house is okay.
House is okay, but there are other houses also, madam, of the neighboring people. I am not concerned. Okay? We'll just, we have also annexed the photographs. I have also annexed the color
Now
photograph.
section 9 order has come. Done.
The Lordship will then fix this, okay, then. It's taken up for the.
I think my, on the point.
Instructions regarding the compensation amount.
How much of the area has been taken?
They do not take the area, madam, just they take the line. About.
So how much area has been taken from your land?
in length,
Notice
madam,
must be there.
32 meter, madam.
Huh?
32 meter.
But the first is 84. 2020,
they
Patta
have annexed,
number
madam,
so and
sir.
so.
Photograph of the,
Area is 2 bighas, 1 kata 7 lecha.
this. 2 bigha, 1 kata 7 is the total area.
Out of 32 bighas.
2 bigha, 1 kata 7 lessons.
So both of you are the co-pattaras of these 2 bighas, 1 kata 7 lecha.
Mother and myself. Mother and myself.
Mother and yourself.
So there is 6 bigha of land, including our houses. The lordship kindly see this picture is bit clear, madam. Very good. Okay. Very good. And this picture bit clear, otherwise the color picture are not very clear. 28 meters.
But your representation, what you have submitted,
That,
is that you want to do some business out there,
yes, construction of one,
not on section 7.
construction of one, ground.
Section 7 will
Down.
only come if there is already a constructed building.
That has been disposed of. Constructed building is there, my, our house is there.
Then-
This picture is bit clear, my, otherwise, color picture is not.
Where?
The red mark is the pipeline going near, just near my house.
They plan to construct a warehouse.
Okay,
Pipeline means nearby.
just nearby.
And what is the road? There is a road going by.
So this
Side?
is not road, there is the pipeline laying here.
Huh?
Road goes from north to south, there is another thing,
But
Red
there is a road out there.
the north south. But the red mark area pipeline, there is a, they are just going through my house.
8 meters from the road.
There are,
So thereafter, have you passed the final order?
Yes, Lordship, regarding the complaint you made.
You have made the declaration.
Have one instruction. Regarding the complaint being made by the petitioner number 2, it has been disposed of.
Huh?
It has been disposed of.
Which one?
There is an order.
what is the animal? Like,
I have received the instruction on 5th October 2022.
Now, have you been paid any compensation?
No,
My instruction is they are not cooperating with authorities. They have.
because
certain
our
documents.
case is otherwise.
The state government or the corporation, as the case may be, shall be liable to pay compensation to such person for damages, loss, the amount of which shall be determined by the competitor at its first instance. Have you done that?
Already amount has been quantified. We are
So
waiting-
under such circumstances, you inform him, if he is not acceptable to that, he has to go before the
There is
district
no
judge.
dispute regarding whether the compensation is acceptable or not. We are ready to pay them if they are willing, but they are not coming forward for claiming that.
Hello? But Mr. Sharma, you don't have a case
Hello?
in view of representation, what you have submitted.
No, they, my lord, I have got a house, this one. And nearby I want to, establish a business house.
Pipeline has been laid, should have got a interim order then, first. Secondly, the representation which you have submitted is that you want to carry on the business. The loss of business can be very well taken
No,
note of,
madam. My
file
lord,
an appeal.
no, business, carrying out the business is not as risky as laying the pipeline and because are plus four pipelines going through that room. Just touching my house. That is totally barred by order section 7.
But that is not your representation. That is not your representation. Why should we take into account those aspects?
That's the, I have said, I have got.
You say that you want to carry out some business, you want to do have a go down out there, and as such, kindly don't do this. This is your representation.
No, Their ability also, they denied, I don't have a recent house, my lord. They have not denied in the ability also.
Okay, Mr. Shah.
My lord, let me come on Tuesday, my lord, I will argue.
Let us have it next year. Better luck you may have. Is this matter again, petition 21st of January 2025,
9th,
Tuesday. I am having it on Tuesday, as you say, but only in the month of January,
the January 9th, one is Thursday is there. January 9th is the Thursday.
21st of January. 9th, that is the first week. Nobody will do work. You also may not be, just after such a long vacation and the winter vacation, another vacation coming, you may not be interested.
27.
Belendra Kumar Shah. Yes.
At the last order, 110, my lord, let's see, first to file the counter by the respondents, my lord. No response has been received yet.
Yes, what is this?
My lord,
I'll have to again repeat the same thing, my lord. This is, matter pertains to Thai Development Council, my lord. Now, these are under Social Justice and Empowerment Department, my lord. We do not deal with this. The WP department is no more. Now there is in bifurcated and trifurcated actually. So this falls within the domain of social justice and empowerment. They have to make a party. They only can, my lord, say anything about this case.
Cecil?
What happened to the offices allotted to WPT earlier? Some office was allotted,
Office is still there, my lord, one.
office is there. What happened to that office?
WPT office, my lord. That office is, building is there.
What happened to the building?
That building is now, my lord, some has been taken up by the social justice or
How? How?
tribal accused.
How? Did you transfer it by way of a deed? Did you transfer it by way of a deed? I'm asking you.
By notification.
No, you are the, whoever it is, we are not bothered. The person who is out there has to therefore take over. Why the petitioner will make all these people a party?
My
It
lord,
is none of their business. It is the duty. How many times it will do?
my lord, unless now this
Mr.
department is,
Mr. Ardor, kindly don't compel this court to say that this all whatever is being done means there is no transfer of the power from the WPT to any of the thing. If there is a transfer of the power, there has been a transfer of the power.
exactly, my
If the transfer of the power, it also includes the assets and liabilities. And therefore, whoever it is, he has to come before this court and say, then look here, I take the responsibility. Is it not the responsibility of the
my
petitioner?
lord, that is what, now this is social justice and empowerment.
I am not concerned. You may have tomorrow, he will make social justice. Tomorrow, the government of Assam may have another 10 departments divulgated from there. So, how does it matter?
My lord,
And is he going to keep on doing this?
my lord,
Then
my lord,
you are to pay. Your responsibility is
My
to
lord,
pay.
my lord may pass any order. I am even not even authorized to, my lord, even appear because this WP department doesn't exist. But as
We
a-
ask the
my-
we ask the chief secretary to appear. Don't worry. We'll ask the chief secretary to, because he has not done anything. It is his responsibility. We have made the chief secretary a party.
Oh, but here only the commissioner secretary of the WPT department.
that is the problem, my lord.
None appears on behalf of the none appears on behalf of the state of Assam as well as.
My lord, that is what, my lord.
Are you appearing on behalf of respond number petitioner respond number 1?
My lord, this,
I'm asking you, are you appearing?
For the WPTPC, we don't have.
No. So none appears on behalf of the respond number 1.
one is, my lord, WP and BC
Okay.
department.
None appears on behalf of the respond number 1, 2, and 3 when the matter is called. Full stop. It has been brought to the attention of this court by Mr. S. Purva, the learned government advocate, that the WPT BT and BC department had ceased to exist. Full stop. Be that as it may, if the said department have ceased to exist, its assets and liabilities, where this court is of the opinion that its assets and liabilities cannot cease merely upon its seizure to exist. It has to devolve upon other authorities. Taking into account the above, this court impledes the chief secretary to the government of Assam as a respondent number 4 to the instant proceedings. Mr. Mohanto, P. Mohanto, the learned counsel appearing on behalf of the petitioner shall file a fresh memo of parties before the registry of this court. Mr. S. Purva, the learned counsel appearing on behalf of learned counsel, government advocate, accepts notice on behalf of the newly impleaded respondent number 4. Full stop. The respondent number 4 is directed to file an affidavit as to who would be making payment of all the liabilities of the WPT and BC department. of the government of Assam, the then existing WPT and BC Department of the government of Assam.
My lord, here,
This matter again on the chief secretary on 2nd of December 2020.
my lord, this pertains to Thai Development
I'm
Council.
not concerned. The registry shall, on the basis of the said instant order as well as the fresh memo of parties, make necessary changes in the cost title as well as also update in the
This is typically no.
This thing after 2 years, my lord, after registration of development.
so that means you don't need to pay.
The current bill I have submitted, Lordship, of rupees 49 lakhs 1,409. In the year 2021 itself, Lordship.
The Mr. R.K. Musari appears on behalf of the PTC authorities and submits that 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 he is yet to receive instructions in the matter, first taking into account the above, list this matter on 4th of December 2024. An opportunity, a final opportunity is given to the BTC authorities to bring on record their stand by filing the affidavit.
31.
We have filed our affidavit in office. We have filed our affidavit in office.
Receipt. Clear receipt, my lord. At 2.
What is this affidavit business?
So I have to find, my lord, I have to find reply.
Second round of litigation, my lord.
Regarding what?
In this prayer, they wanted to release of the machinery and the materials lying inside my FSC, my lord.
Oh, this one. You have filed the affidavit.
Yes.
Let him file it. Please this matter again on 24th of January 2024. In the meantime, the petitioner would be at liberty to file the.
Plus by.
Are we allowed to withdraw the application? Says the grievances have been made.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. Mr. J.K. Goswami appears on behalf of the state and submits that the due payments have been already released. Taking into account the above, the writ petition stands closed on withdrawal.
33.
Yes, who is appearing for the government? Has the presidential assent come for amendment?
Yes, last time, Lordship, we have directed, but I'm of the file, I couldn't find out whether the communication has been granted. So let me have some extra time so that I can.
File in if my lord.
Here is a case where permission, it has not been granted, na?
Yes.
You asked for what? Sale permission?
Deed has been executed on commission, but the deed has not been delivered by the sub-registrar, my lord.
Why?
On the ground is notification.
On the ground of SOP, my lord, but.
Sale deed has been done.
Yes.
Sale deed has not been handed over to you.
Yes.
What is your prayer? Direct why the executive there shall not be delivered. Yes, why you are not delivering it?
Lordship, for that
That
matter, I
cannot
have-
be a ground. First of all, you have not got the presidential assent till now. And if you get it also, you cannot give a retrospective effect from there. Then what is this?
the necessary documents which were to be submitted for the sub-register hasn't been submitted. That
What
was the-
necessary document?
So these are I have already mentioned it in my affidavit.
What?
The, senior sub-register has sought the registration fee challan, NOC for construction, occupancy certificate, valuation of construction area and valuation of the proportionate share of land, but these were not furnished when the sale deed were presented.
Valuation of the constructed area.
Yes.
Registration fees challan has been paid.
But the petitioner failed to furnish the other document. NOC for construction. Construction of the entire building. Occupancy certificate. Now, is it in Guwahati?
No, my lord, in Vijayanagar, the village area. But as per the government notification, my lord, in the village area, no permission is required for construction of building.
So no construction is required for construction of multi-state building.
Permission is required from any authority.
NOC for construction, occupancy certificate, valuation of the construct. Why do you need the NOC for construction and occupancy certificate?
This is as per the guidelines set in the notification of 6/12/2022. So as regard.
No, no, no. Where is it? How can you have?
So this notification is also a part of my affidavit.
No, no, this notification doesn't have the presidential extent.
Yes.
Then this notification is bad. That is not there. But why can you insist upon the occupancy certificate in the NOC? What business you have? We direct you to deliver it to you on the basis of the registry challan. Oh,
Yes.
done.
That's it.
And why do you need the valuation of the constructed area?
Those I'm not sure, but as regards the area where the building is situated, so that has been specified in my.
No,
affidavit.
are you the GMD or the GMC? What business does the DC have to do all these things? The sub-register has, or the senior sub-register has. You have a particular question to be done. There are a lot of judgments of the Supreme Court to that effect. You have no business. You are not to even see the title also. You have no business to see the title. So under what circumstances, under what provision of law you are doing all these things? 21A is only provision which states that they require a no objection certificate. But there was it was categorically observed by way of an amendment that no objection certificate is not required in such circumstances. Now you want to take away from that. Then if you want to take away, you have to amend it. Now how do you amend it? You can only amend this.
So far, I have sent, so already in 2024, another notification has come in and which says that those documents are the necessary part before granting the said permission.
Which notification?
So I have to place.
No,
NOC.
that notification has not come in. I'm telling you why. What has happened is initially you come up with 21A. Then there was a further amendment made to 21A by which a presidential consent was taken. And that was inserted where it says that there is no requirement of taking any permission or NOC in respect to flats. Now, thereupon, now what has happened, you have thought it, okay, now we require these flats permission. So you want to amend it. So now amendment has not happened taking into account that you have not got again the presidential consent. So if you have not, so you are now imposing a memorandum of an office memorandum by which you are asking them that kindly give pending this. Under what provision?
So Lordship, let me have my specific.
Tomorrow. Is this matter tomorrow
Day
at
after
2?
tomorrow.
Tomorrow.
My humble request.
Tomorrow. 2.
Correct.
2 o'clock.
Yes.
Is this matter tomorrow at 2?
So 38.
Yes, what has happened?
Order dated 26/9 maybe paid those minutes. And my lords, in compliance to that, my lord, we have thought out a proposal and sent it to finance for approval, my lords. As regards the payment of the principal amount claim, my lords.
Then
And funds.
payment.
Once the finance gives, my lord will give up.
That is the main problem, Mr. Gogoi. You also understand, I also understand. But
Finance
all,
also asks to appraise.
it seems that the departments can't get it done or won't do it.
Without
Always,
finance
always
compliance, we don't-
blame the finance.
No, they're just kind of shifting the.
Yes, Mr. Pinag, you are the finance. He's a party here?
Yes, finance is a party.
Yes, why? What has happened? Why you are not releasing?
proposal to push ahead. Let me just discuss. He's saying that.
Lordship, this has been going on for donkeys years now.
When did you give the proposal? Where's this proposal? This type of communication, Mr. Gokoi, won't help. When you did the proposal, then we can ask the finance to ask me.
That,
Or the PHE has only issued one proposal all these years. Then the finance should not be so reluctant to grant it if this is the only proposal you have sent.
no, my lords, we have,
So there is a number, no?
yes, my lords. I
Right.
can provide the number, my lords, not now. Right now, I don't have.
Last item of the day?
Tomorrow, man.
No, last item. Get the number. We'll ask him only. Last item, last number. We don't require much. What is the proposal number so that I can ask him what is happening?
Yes, my lord is correct, perhaps. They should have annexed the proposal here. They should have annexed the proposal. In spite they had what they had done, they had annexed my letter.
Last item of the day.
Hmm, 39.
Yes, madam, what is your case?
I'm aggrieved by a decision of the City Municipality Board, my lord, is at annexure 6, my lord, by which, my lord, the permission for sale of my land, which was granted earlier, was kept in abeyance on the basis of purportedly one complaint by respondent number 4. Lordship, if I may take your,
Senior sub-register. Who is respondent number 4?
respondent number 4, is, my lord, one private respondent.
No. Who has kept you in abeyance?
My lord, Silchar Municipality Board, my
Huh?
lord. Silchar Municipal.
Yes. When did you start entering into or venturing into the private disputes of two persons? Let them get an injunction, you do it.
They didn't get
Why
the
you are-
injunction, my lord.
They have failed to get an injunction and it will be always subject to outcome of the suit. Recently, the recent judgment of the Supreme Court has come from the date of filing of the suit will be the date that 52 will come in. So, what does it matter?
Multiplicity of proceedings.
So what? Multiplicity of proceeding 2210 will hold the field. No problem. You don't need to make. Party is not required. They will come. And they will always adopt the same stand which the petitioner is making in the suit.
One question is that section 53. They will take the plea of bona fide purchaser without notice. Purchasers, they have permission was issued. Permission was issued, but when we lost the complaint, it has been kept in
There
evidence.
cannot be a bona fide purchaser with notice taking into account when the suit is filed, it is deemed that they have notice.
But when the,
You insert it, one line out there. The suit is pending.
my lord, I have said this.
No, not
Yes.
here. Sealed it.
Yes, ma'am, yes. That we are ready to, and the buyer also is ready.
Well, your bona fide purchaser who goes. Your problem is there, that it will, so he will know also. Or don't want to spoil it, don't, just give him a notice to that effect that this is it. No. If we are going to take a suit pending, then also we are.
No difficulty, no difficulty, ma'am.
How does it matter? And then when the case is pending out here, an order is being taken from here, there's a suit pending, any sale being made. You got an injunction, you failed to get an injunction. You should have come before this court. When I was sitting bench one, I would have granted him one. Look. And Mr. Doctor, I don't think you are going to intermeddle in the affairs.
No. We don't have in fact any cases.
They heard me speak Chakravarti, the learned counsel appearing on behalf of the petitioner, Mr. As Doctor Learned Senior Counsel appears to represent respondent number 1. Esbora, you are there? appears on behalf of the respondent. Mr. S.D. Prakash appears on behalf of the respondent number 4. The petitioner herein is aggrieved by the action on the part of the respondent numbers 1 and 2. Action on the part of respondent number 2, 1.
One.
Action on the part of the respondent number 1 in that by issuance of a communication dated 2/2/2022, whereby the senior sub-register Silchar was directed to keep in abeyance the land sale permission number MP/LS/NOC/02/2021-22/8163 dated 26/10/2021. On the ground that there is a complaint pending before the said authority. Ms. P. Chakravarti, the learned counsel appearing on behalf of the petitioner submits that pursuant thereto, the additional deputy commissioner, Kachar, had also written a letter to the senior sub-register on 3rd of February 2022 that in view of the pendency of the civil suit being title suit number, how much? Title suit number? 1757/2000, 157/2019. The NOC issued from the office be kept in an abeyance until further orders. The learned counsel appearing on behalf of the petitioner submits that though the suit was filed and an injunction application, though the suit was filed by the respondent number 4 and an injunction application was filed, there was no injunction so granted. The learned counsel submitted that the revenue authority as well as the municipal authority are taking steps, are dictating, are acting, have taken the role of the civil court and is not permitting the execution of the said sealed deed, which is nothing but an excessive executive overreach. Mr. As the learned senior counsel submits that taking into account the pendency of the suit, the impugned notice communication dated 2/2/2022 was issued pendency of the suit as well as the complaint filed by the respondent number 4. The communication dated 2/2/2022 was issued. Mr. S. Borua, appearing on behalf of the additional deputy commissioner Kachar, submits that in view of the pendency of the suit, the direction was issued to the senior sub-register not to keep the no objection certificate in abeyance. Mr. S.D. Purkar, the learned counsel appearing on behalf of the respondent number 4, submits that taking into account the suit is pending, any transfer so made would amount to creation of third-party rights, and it would be then difficult for the purpose of it would result in complicity if a decree is passed in favor of the respondent number 4, who is the plaintiff in the suit. I've heard the learned counsels appearing on behalf of the parties and have also perused the materials and report. From the impugned orders dated 2/2/2022, as well in communications dated 2/2/2022 and 3/2/2022, it reveals that both the respondent number 1 and 2 have acted, have directed the senior sub-register not to act on the permission so granted on the basis that there is a complaint pending as well as a pendency of the suit. Further to that, be that as it may, it is very pertinent to take note of that in the said suit being title suit number 157/2019, an injunction application was filed before the trial court seeking injunction not to transfer. However, the said injunction has been refused. Under such circumstances, it is the opinion of this court that the respondent number 1 as well as the respondent number 2 would not have injuncted in exercise of their powers on the basis that there is a pendency of the suit in a this court have also taken due consideration to submission made by Mr. S.D. Purkasta, the learned counsel appearing on behalf of the respondent number 4, who submits that any transfer so made would lead to multiplicity of proceedings. In the opinion of the court, the said submission is misconceived, taking into account the provisions of Section 52 of the Transfer of Property Act 1882. It is further to that, it is at this stage relevant to observe that any transfer made during the pendency of the suit shall be always subject to the outcome of the suit. Under such circumstances, this court finds no reason as to why the respondent number 1 and 2 should direct the instruct the respondent number 3 not to go ahead with the sale, not to proceed with the execution of the deed of sale. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The impugned communications dated 2/2/2022 as well as 3/2/2022 issued by the executive officer of the Citizenship Municipal Board as well as by the additional deputy commissioner, Pachar, respectively, are set aside and quashed. The sub-register, that is the register respondent number 3, is directed to register the deed of sale to be placed by the petitioner as well as his or her, as well as his
Seller would be his wife. Seller would be his wife.
seller. Submitted by the petitioner. Submitted by the petitioner, na?
Yes.
Shall execute the deed of sale on the basis of the permission number MP/LS/NOC/02/2021-022/816 dated 26/10/2021. It is further directed that in the meantime, if the said land permission had expired, the respondent number 2 shall do the needful so that the said permission is extended. Also, this court further observes that the said sale to be made by the petitioner shall be subject to the outcome of title suit number 152-7 of the 2019.
Apply. 40.
Yes, what is
And I
this?
am preparing on behalf of I, Hussain Lordship, and he needs some time to file affidavit in reply.
For what?
We have filed the affidavit in.
What is this matter about? This is how many times you have asked for time for filing reply?
As per the instruction,
In the meantime, petitioner would be at liberty to file the reply. Huh? The counsel appearing on behalf of the petitioner seeks time for filing reply. It is seen that on the earlier occasion also time was granted to do so. Accordingly, list this matter again on 19th of February 2015. In the meantime, the reply be filed.
41.
Yes.
yes, ma'am. No, that was cancellation of GST matter. And my GST.
What has happened to those cancellation of GST matters?
Today listed.
What happened?
What's the
It's here?
No, no, here, let's see what happened, they prepared appeal.
Is the series here? No.
No, no, it is not, it is, November. Here, let's see, they filed appeal was dismissed. Beyond time, citing some Supreme Court judgment. The authority is no power to condemn that appeal. Last occasion.
What happened to those matters?
Firstly, they are pending
Fix this now. I am not here. What happened?
today listed, let's say, the item number.
Before court number?
44 to 47.
For another court?
No, no, before you.
Those, that series
Yes.
is there. On the basis of the information has come to light that you have not furnished. Did you submit a reply? No reply.
I have.
And they cancelled it. So we passed the same order which I used to pass. Where is that?
But our High Court has already decided the issue regarding this aspect.
The council don't come up with that respect. I have passed some orders. Where is the orders? No orders, no cancellation. Huh? It is that order which I passed, no? So directing them, the cancellation remains as it is, it shall remain suspended. He shall submit a reply within some days and then you pass the order by giving reasons. That's all. That is what I pass. Because here there is no reasons. But where the otherwise the reasons are there, then I had kept those files differently.
If there is no
We
reason.
can dispose of this matter. Ask an order to. Yes, Mr. Counsel, I dispose it off.
Yes, ma'am.
You submit your reply within 10 or 15 days. I forgot what
Yes,
is
ma'am.
there. I forgot. Then you submit your reply. The cancellation, it goes back to the date on which the notice was issued. Means that is the date on which the suspension happened. And it shall continue till they pass an order. Okay?
Oh, yes. Yes, sir.
Because there is no reasons.
Yeah.
Dispose. Get your name.
43.
Otherwise, I will say none
Yes, sir.
appears, then also pass that on. Yes, but
Yes,
see,
last of the Lordship has directed me to produce the record pertaining to the annexes of the enquiry report.
hmm.
Although Lordship, I have received the record, but it is not proper Lordship. So I need some
Huh?
further
Place before this court the copies of the enclosures to the sale inquiry. You have not got
enquiry
it.
report. Although I have received, but it is not proper. I need some further time. Lordship.
The SR Bulwa appearing on behalf of the learning government advocates seeks some time to provide to produce the enclosure in terms with the order dated 8/11/2024. This matter again on 4th of December 2024.
247.
Matter was relating to cancellation of registration value.
Yes, Mr. Kyle, you are not there? Anyway, all these matters are taken up together, na? 47, 44 to 40. The state council takes some time to come. Yes, they are not bothered much on the revenue. State has got a lot of other revenues. Yes.
Cancellation of registration, GST cancellation. So as far as affidavit, that limitation period for restoration was over. So as on that, there is no provision in the GST, state GST or another GST for restoration of that.
No, that is not a problem. Restoration can be done under 226. That's not a problem. But the problem is, it has a lot of ramifications. Just for example, a person concerned has to pay. Has to pay an amount. He does not file his return. 6 months, he does not file his return. So you cancel his. He keeps quiet. He doesn't do anything. And one fine morning, after 3 years is over, he comes up and files a writ. I allow it. Now, he can now be directed to file his returns. Can you pass an order for that period? Because for filing of the annual return, there is a particular period fixed. From there, 3 years, 73.3, 73.1 and 73.9. Can't the person escape like this? This is one. Secondly, he files a return. He does not file a return. Thereby, it is affecting those persons who comes under 16.2. They have a problem. And thereby, orders being passed out there, then they don't take action under 73 in view of this 16.2. There is a division bench order. They get escaped. Nothing is there. He does not file his return. How do you take care of a situation of these type of cases? Normal cases is okay. Those cases just now I disposed of, no notice reasons have been given, so and so. But here is a case, Mr. Todi's client, if I remember correctly, then when it happened, he went into a quietus for 2 years, saying that I have left business and all, I'm not bothered. Now he wants to come. He wants to come on the basis that let me come back. Therefore, the question is, my question which was before you on the last occasion is, a person whose registration has been cancelled, can he apply again?
Yes, then we have said in the affidavit, only recourse left with the petitioner is to file a place for press registration.
No, okay. What happens to the earlier period? How do you take care of that?
45, madam.
No, that is 45 is only for the period then, till the cancellation. So that is why. How do you take recourse to this thing that they, for last 2 years he has not filed? Nobody knows anything. Yes.
Section 16.6 has been inserted. If the registration is restored, then it will be allowed to file it.
Section 60.
16.6, new section is been added. 16.6.
So you have got the new book. The registration of a is cancelled. Section 29. What is this?
Then they will be allowed to subject.
No. Why you are reading like that? What about number 2? For the period from the date of cancellation of the registration or the effective date of cancellation of the registration, as the case may be, till the order of revocation of the cancellation of registration, where such return is filed within 30 days from the date of revocation of cancellation. So they have to file, then input tax credit can be taken.
It is restored, either by court or otherwise.
And then we can direct them to file their returns within 30 days. And then only that person will get the benefit. And how do you then take care of a situation as regards, does the period of filing of the returns is extended under 73? Huh? Because that is a very important issue. This section 73 says the proper officer shall issue the notice under subsection at least 3 months prior to the time. Time is given in 9. The proper officer shall, after considering the representation, if any, made by humans, proper officer shall have within 3 years from the due date for furnishing of annual return for the financial year to which the tax not paid or short paid or input tax wrongly availed or utilized relates to, or within 3 years from the date of erroneous refund. So this is 3 years from the last date. So the last date would be, as per the financial year, would be 40 something. 40, na? Returns. Furnishing of returns, 39. And 40 somewhere is there, somewhere. 40, first return, every registered party also and so, availment of annual return, 44. Final return. Every registered person who is required to furnish a return under so and so and whose registry has been cancelled shall furnish for a final return within 3 months of the date of cancellation or the date of cancellation or the date of cancellation, whichever is later. How do you take care of that situation, Mr. Dr. Toti?
So far as my case is concerned, it's a different footing altogether. Yes, my lord, for other case, my lord, I am not aware of. But for my case, my lord, if you lordship will kindly see that, my lord, says so-called notice within violation of section 29, proviso, subsection 2, proviso. That says that my hearing has to be given, and lordship will kindly see. If for time being, my lord, lordship may kindly turn to page 19 of the petition, my lord. If I am able to read, my lord. What is written, my lord?
No. Then why should we at all entertain after such a long period?
Yes, I'm coming.
No, I'm not on that.
But I'm,
Therefore, the question arose as to why should this court at all entertain these type of matters? Yes, natural justice, some orders without any notice, nothing is then definite. But entertaining at a very belated stage has far-reaching effect.
in fact, my lord, belated stage, my lord, Lordship, kindly see, my lord. What happened, my lord? When, my lord, we came to know, my lord, yeah, in fact, because it was in a portal, uploaded in portal, my lord. So portal, my lord, when, my lord, the persons who will, my lord, very busy businessmen, my lord, they see often on, my lord, portal, my lord. There is a case, my lord. The petitioner came to know only 2021 with regard to the cancellation of the, my lord, registration that was done in 1919, my lord. Then what happened, my lord? They approached for correction, my lord. So, my lord, since the time, statutory time was over, my lord. So, my lord, then, my lord, the appeal was filed. So, appeal was disposed on 2024 only, my lord. That appeal was disposed, my lord, that's it, which belatedly filed. They were disposed on 6th April 2024, my lord. So, my lord, the petitioner, my lord, what happened, my lord? Petitioner, my lord, in the January 2024, paid tax also, my lord. Whatever the due tax as per him, it's about 63,000 was paid to them, paid by them. That was not denied also, my lord.
No, how do you pay the tax?
Paid, my lord, as per the, my lord, own calculation, my lord, whatever the, whatever the liable to pay, my lord. It's not liable.
But can you pay a tax or file a return without having a registration?
Yes, my lord. No, what happened, my lord?
As a non-registered?
What happened, my lord? Lordship is, my lord, posed a very important question to me, my lord. In fact, my lord, what happened when the portal was opened, my lord? So, my lord, the businessman, my lord, he is not a big businessman, my lord. So, what he did, my lord, when the portal was, my lord, he could file pay tax, my lord. It was paid, my lord, in January 2024. 63,000 was paid. Then happened, my lord, but then the subsequent period, my lord, then when they come to know, perhaps that was blocked. So, thereafter, my lord, he could not pay. Now, the moot question arises, my lord, here. So, my lord, since the, my lord, it's aim of the petitioner is concerned, my lord, not to evade the tax, my lord. In fact, like to make the payment. And but so far state is concerned, my lord, it is not, the state is also not stand to gain by cancelling the registration because they are on the technicality of it. When the statutory period is, my lord, at 30 days, the restoration of the cancellation, everything was, but my lord, statutorily, my lord. So, but that time was over. So, when that time was over, my lord, now the provision says that even after cancellation also, the petitioner is not escaped. He is to pay the tax. Whatever the liability is concerned, even the after cancellation also, my lord, as per provision, because they are to inform the petitioner to the my lord, registered dealer that you pay, no cancelled, my lord, that for the period they are liable to pay. Because since they had the earlier registration, so they have to pay. So, my lord, they had to pay, they paid. So now the my lord, what reports is available and how, my lord, department will be benefited as well the businessman, my lord. See, indirect tax, my lord. Law is a different question altogether. Lordship, aware, my lord, what is direct, indirect taxes, and how, my lord, the petitioners, my lord, can be, my lord, both sides should be at par, because department should not be at loser, and the, my lord, unnecessary and again, petitioner cannot stand to gain unnecessary demand. And, my lord, whatever tax is, my lord, returned, because Lordship is aware that, my lord, when the bill is submitted, he will include GST as well. And GST, my lord, while making payment, my lord, is bound to deposit the GST, whatever collected, whether afterwards or beforehand, to the state exchequer. Bound to pay. You cannot keep with him. And suppose there is delay in making payment, my lord, the interest as per as leviable, my lord, as per statutory required, my lord, that has to be paid. Interest as well. Now the question, my lord, moot question here, my lord. Here, my lord, when, my lord, the base, your, my lord, Lordship is, my lord, said that, my lord, they come belatedly, my lord. Because belatedly, not intentionally, my lord, because here, my lord, 226, my lord, when, my lord, they had all options are closed, my lord.
No, Dr. Dodi, I am not saying about your person coming intentionally or not intentionally, I'm not on.
My lord.
But I'm seeing on a larger issue.
My lord.
If in a case, a person is allowed to come and we just restore it without having anything, then how do we do it, taking into consideration that if he comes at a belated stage and he does not, in the meantime, 73 period is over, then how do you take care of a situation there? Can the authority then take recourse?
In fact, my lord, Marquis Honorable Court, my lord, in number of judgments, my lord, but already stated, my lord, had taken the view that my subsequently after the cancellation, registration, my lord, if my time was given, granted a 2 months period, but they will offline, they will file the return. as well as the whatever the, my lord, the penalties and interest are required to pay, they will pay, then it will restore back, my lord. So there are 2-3 judgments are there by the Honorable Court, my lord. So for the coordinate bench, my lord.
Earlier judgments are good. There was no problem. You see, this is the CGST Act is an act by which they fix a limit. No, all other cases all other enactments are different, where there is no mention.
My lord.
That here it is stated that you have to complete it within this period.
My lord. But here is the case, my lord. Your lordship, my lord, on the other day, the judgment, my lord, this judgment has set at rest, my lord. Many of the, my lord, the controversy that has been henceforth been continuing. Because in chapter 3, which of the, my lord, the provisions are there, that have been incorporated by lordship, my lord, that the speed has been taken, and my lord, that the authentication of the, my lord, notice. So, my lord, a notice, bag notice, suppose is served upon the dealer. So, my lord, from the date day, my lord, suppose notice is per se illegal, arbitrary, my lord, then everything goes away, my lord. Subsequent actions are all goes away, my lord. Meaning thereby, my lord, if my lord lordship is convinced by notice, whether it's a notice in the eye of law, whether cancellation in order, suppose that is not there, my lord. And my lord, now the second part will be there, whether the petitioner will get the benefit of taking a chance to evade the tax of the state taxes, then perhaps, my lord, no. Because whatever my lord, the shortfalls are there, but the lacuna is there in notice, whatever it may be, my lord, but it won't come to rescue. But here is the case. My lord, it is one both are equal footing, my lord. It's not that the defaulter, the petitioner itself is defaulter. Even notice itself, my lord, is statutorily required to be fulfilled, my lord. Where is the hearing, my lord? 49, my lord, the proviso said that without hearing, you cannot cancel it. But where is the date? When my let them show, my lord, when the hearing date was fit, where the venue is fit, what is there? But nothing is, everything is silent, my lord. If I read my lord notice, my lordship will kindly see the notice at least once, my lord. Then lordship will be convinced that, my lord, whether it is a not in the eye of law or not, my lord. And the cancellation, my lord. But if the two letters, two notices will be sufficient to, my lord, come to conclusion, my lord. Page 19, lordship, my lord. Page 19. As your lordship got, my lord. Page 19 of petition.
Yes.
May read, my lord. Whereas on the basis of information which has come to my notice, it appears that your registration is liable to be cancelled for the following reasons. 1. Any taxpayer other than composition taxpayer has not filed returns for a continuous period of 6 months. The standard, my lord, whatever is there. You are hereby directed to furnish a reply to notice within 7 working days from date of service of this notice. If you fail to furnish reply within the stipulated date or fail to appear for personal hearing on the appointed date and time, the case will be decided ex parte on the basis of available record on merits. So, madam, where is the date? When the date is hearing speak and what is the venue? Then lordship will kindly see the cancellation. The next page, madam, 20. This is very important, madam. Cancel registration. This is which reference to your reply dated 17/11/2019. Whereas, well, we didn't file any reply. We were not aware. In response to the notice to show cause dated 6/11/2019, whereas no reply to notice show cause has been submitted. On the contrary, my lord. The effective date of cancellation of your registration is 18/11/2019. Determination of amount payable pursuant to cancellation according to the amount payable by you and the computation on the basis thereof as follows. The amount determined as being payable above are without prejudice to any amount that may be found to be payable on you submission of final return furnished by you. You are required to pay the following amount on or before 28/11/2019, telling which the amount will be recovered in accordance with the provisions of Act and rules made thereunder. 0000, my lord, there is no amount. So, my lord, if your lordship kindly appreciate this, my lord, notice as well as, my lord, their cancellation order, then lordship will be convinced that it will, my lord, directly, my lord, the notice, the fake notice, my lord, is not authenticated, not signed, no hearing was mandated hearing required, my lord, to give under section proviso to section 29 subsection 2. That has been completely, given a go by. Then, my lord, abruptly, my lord, this order.
What is the relevant rule for that?
My lord.
What is the relevant rule for
Yes,
that?
my lord, I'm coming. First section, notice you can see section 29.
Cancellation, registration.
Section 29, my lord. First,
No, that I've seen it.
Section 29.
Yes, where the officer has reasons to believe that the registration process is liable to be denied. He shall issue a notice to such person in form GST number 7 requiring him to show cause within a period of 7 days from the date of service of snuffer as to why his registration should not be cancelled. The reply of the shall be finished in a month within the period specified in the same subgroup. Yes. A person, when a person who has submitted an application for cancellation of his return let me go through this 22 and 23. But 22 does not conceive of a hearing. It doesn't conceive of a hearing. What it says a notice will be given, a reply has to be served. 22, Rule 22 does not say about a hearing.
But section says 29 provides you section 2 provides you my lordship.
And 29, does it say about a hearing?
Hearing, my lord. Yes, my lord should be heard. Not giving a hearing, my lord. Similar condition.
The opportunity of being heard is and so cause.
But
This is a different thing. Whereas in earlier cases, 73 proceedings is not a different thing. Therefore, here they only issue a notice asking you to reply. And in the meantime, if you submit your return along with your everything, proceedings will be dropped. So this is it, what is there. Again, we do one thing.
Also, my lord, the lordship will kindly appreciate on the other day, my lord. Lordship held the view that, my lord, in fact, it should be authenticated without authenticating, no notes in the eye of law. As it may by Telangana, Delhi High Court, my lord, because my lord, that said that without authenticating, lordship has, my lord, even went, my lord, a step further by bringing the, my lord, that the authentication requirement, though containing.
No. In those cases, there were no notice like this. These were not the notices out there. They gave only the DRCs. In those cases, they had only issued the DRCs. They did not issue notice. So therefore, therefore I say that those notices, DRC maybe electronically you may have it, but the notices has to be there, which has to be authenticated in the manner prescribed. That is what I say. But these were all cases of DRCs. DRC 1 who has been issued. Only the format. So here, that rule 149, if I remember correctly, categorically mentioned that the notice has to be issued, which is to be accompanied by a DRC. Here, what they did only gave the DRC, not the one notice.
Allow me to submit. In fact, on the other day also, my lord, I made a statement that, my lord, in fact, like my lord, so far the act is concerned, so are in the 100 after, my lord, so many, my lord, the contradictions, anomalies are there.
No, Mr. Dr. Todi, the act is perfect. But the thing is that the officers are not well equipped.
But my lord, in fact, my lord,
Contains every minute details of everything. But the question is the what you call the officers are still thinking as regards the VAT or the Central Excise or the Finance Act 1994 is. So therefore the problem arises. Here you have got each and every opportunity is being provided. This is how it is being done, but this is not being followed. This is so beautifully done as regards how it categorically says that when they submit a reply, and you think of passing an order against him, you have to give a hearing. Just see, which is never there. This is the act, the rules categorically conceive of. I think 107 of I forgot. So this is it. So these are normally not found in all other acts or rules. They are minutely taken.
In fact, my lord, before we're enacting, my lord.
We do one thing, and Dr. Todi, we have it as parted, we'll fix it at the 28th. I will allow these petitions. Only worry was to look into this, how it is there. I will allow it, taking into account 16.6. Only problem which I was facing is how to take care of those 73, what will happen? Can it be issued, can 73 be issued upon a person who does not file a return? That can be done. Irrespective of cancellation done or not, it is immaterial. So then, irrespective of cancellation, you can still do 73. So then I'll dictate the order on 28.
But the relevant section, which I section 39 in our case, my lord, because of this, the 73 talks about assessment, etc., my lord. So 39 will be better for you return. And my lord,
No, I'm not on that. I'm only worried to the effect that whether a person concerned can take the benefit of not filing a return for 3-4 years. In your case, it is 2 years, 3-4 years.
No, my lord, in fact, my lord, once one portal, 6 months, my lord. But once it is cancelled, my lord, the portal, my lord, they block the portal, my lord. Or they will confirm that the department. The once they block the portal, money is in spite of the wishes of the dealer, he cannot file. Because they cannot go to the portal and file it.
No, that is why I'm saying you don't file it.
Now, my lord, what happens, my lord?
Then would they be stopped from taking 73? That is what my issue is. But because the 16.2 is duly taken care of by 16.6. But we have to direct that if you are to file your return, you have to do it. The AR is subject to you filing your return within 30
Correct,
days. So that I'll pass the order. I'll have it on 28. List these matters on the hearing being complete. List these matters again on 28/11/2024 at the top of the list.
In fact, my lord, why GST was enacted, there were two main discussions that, my lord, for India, but it's a premature because, my lord, they're not well equipped, my lord. And because so whether it will be just takes for USA, my lord, still there is no GST. So that's a fine tuning is required, my lord, both from both sides. And both sides are how fine tuning. Anyway, my lord.
Item 48 to 50.
Yes, what are your cases?
That's it. In the beginning, I beg to submit that certain interlocutory applications are being here with connected restrictions to be decided. Now, let me come to the order passed by the Honorable Court on 19/7/2024 so far. WPC 2485/2024 is on.
Understood. What are you challenging?
No, I told in the last episode that I will file a reply affidavit against the counter affidavit filed by the respondent department. There are two respondents, one is finance department, other.
You want to file your reply?
No, because counter affidavit itself is defective. They did not file full counter affidavit. Kindly go to the order passed by. What's it? Your order may kindly tell it. 19/07/2024. Para 6. 19/07/2024. Para 6.
In which case?
2485, we have filed, the chief engineer has filed an affidavit.
No, they have not filed completely.
Hello, what do you want to do now?
No, because here it is written, order mainly, order dated 19/07/2024, para 6. It is also noticed that there is an additional affidavit filed. But they have not filed the counter affidavit against the additional affidavit. They had filed the other affidavit. Additional affidavit.
We have filed the affidavit in main case. It will anyway cover the.
No. Now,
Hello, okay. What to do now?
now it is.
In fact, Lordship, the nature, it be the instruction, Lordship. The petitioner has challenges certain tender process, Lordship, which has already been completed. And the two tender process.
He wants to hold accountable some officer whom he doesn't like.
Lordship, let me submit,
Isn't it?
It has been personally made party, but I will present it. Lordship, I beg to submit. Lordship, I beg to submit.
Hello.
The order
These
is
matters. These contracts are over.
Contracts are over. One work lordship, 100% work has been completed, other one 65% has been completed.
Yeah.
So it
Let
is-
us see how much time it will release these matters again on 18th of February 2025.
with
An
the- with-
attempt shall be made to dispose of the
Not in
petition.
lordship, if there are 6 additional activities to be explained.
18th February 2025. Okay? The weather is getting colder. We'll get a weather when it is becomes slightly warmer.
25.
Yes.
Keep the instruction log.
Huh?
You have received instruction log.
What is this matter about?
And keep-
No,
The respondent has acquired the land without any procedure, my lord.
Hmm?
In this matter, the petitioner's lands were acquired by the respondent authority without any procedure, my lord.
Then
And also,
no compensation.
neither any, this is notice to grant petitioner, my lord.
Why you not filing affidavit?
So we have
Water resource. You have not paid a single penny, no award, no acquisition proceedings?
as per our instruction lordship, at that time when the land were acquired, the list was given to us. As per that list, we have paid the compensation lordship. They have now come up with this plan. The land is acquired.
So you paid in terms with some acquisition proceedings?
Yes, lordship.
Produce the acquisition proceedings? Under what acquisition proceedings?
As per my instruction, a paragraph here is that during the construction of the dike,
Mr. C. Sharma, I'm asking you, there can be a deed of sale which they can make it in your favor, one, or has to be a vesting of right by way of a statute. So this vesting of right can only happen if there is an acquisition. Acquisition means the acquisition and the law, not as per what your water resource department feels like. Give me the acquisition number, you get the records and see.
section I don't have.
That is what. Don't come up with this type of excuses. Make these some excuses somewhere else, not me for me. We have already paid. How can you pay to anybody?
At that point of time, when the
At
dike-
that point of time means, do you think that, okay, their money, we are paying it? Is this the law? Then, unless there is an award, why will he go? The instant writ petition has been filed challenging the actions on the part of the respondent authorities in taking over the land of the petitioners in the year 2008 without following the due process of law. Mr. Shisha, by appearing on behalf of the Water Resource Department, submits that subsequent to a list being prepared, the Water Resource Department had disbursed the amount to the persons concerned. This court, upon hearing the parties, is of the opinion that the vesting of the right over the land in question can only happen on the basis of the land acquisition proceedings or by way of a deed of conveyance. Admittedly, there is no deed of conveyance. Under such circumstances, this court directs both the district administration as well as the Water Resource Department to place before this court as to under which acquisition proceedings the lands, which is the subject matter of the writ petition, was acquired. List this matter again on coming back 18th,
My lord,
1812.
my lord. Extra copy not served to us. My lord, in this matter, in page number 5 and 6, my lord. Page number 5 and 6, my lord. Page number 5 and 6, my lord.
What is that?
Dark number wrongly printed, my lord.
You have mentioned wrongly.
Dark number-
Correct it. What do you mean? Yes, madam, what do you want?
Extra copy not served.
Madam? Sorry.
Item
If the
52.
court is trying to help you, also you also help the other side. Yes, same matter. Same matter.
In this petition, we have filed out. In this petition, we have filed out.
Land acquisition proceedings. It will be same order. Exam.
This matters also, file a page number page, same problem in this also.
You file an additional affidavit saying that there is a mistake, so this should be read like this. Okay? In both. So
Item number 3, I filed an affidavit. It's not on record. It's not on record. My affidavit. We have. And not-
yes, what is this?
54, I have to file an affidavit. I got their affidavit opposition only yesterday. So I need a few days' time, just a few days, and the matter can be.
Who has filed affidavit?
The ONGC.
We filed out.
When?
Day before,
I got it
on Monday, we filed.
You is who?
And for ONGC lodge, that's 114 lodge.
So I need.
It has been submitted by Miss M. Hazarika, the Lilly Senior Counsel, that taking into account that an affidavit has been filed by the ONGC, she would she would ask her instructing counsel to take instructions from the client as to whether they would like to file a reply. This matter, interim order is there.
It's there, but so a short date.
No, but from July, I had the interim order. ONGC was sleeping over it. They appeared, they filed their wakalatnama. Now, all of a sudden, they wake up.
But Lordship is with regard to maintaining the oil leaks.
Whatever it is, what were you sleeping
On-
on this while for?
We have it on 9th of December.
20, Lordship. 20, next Thursday, Lordship.
No, I don't have time for it.
Nine.
You see, these matters will fall on me. It's not possible. And let me have it on 9th. Let them file the reply by 9th. Then you ask this matter to be listed in the last week. I'll coming back. This is on 9th of December 2024. In the meantime, the respondents, the petitioner would be at the liberty to file the reply. Full stop. The counsel appearing on behalf of the ONGC submits that there is an interim order and expresses urgency. Full stop. The counsel, this court observes that if the ONGC is agreed by the interim order, they are always at liberty to file application for vacation or modification of law.
So that was filed and heard also. After that was heard. And thereafter. it was
Vacation has been filed by them already by.
What has
on
happened?
number
Oh, why? No. Then we could have taken it up on 28th for that.
We have
Finish that,
28 Lordship.
for vacating.
No, but after that, after they filed the 226(3) petition, Lordship, matter was heard and the stay order was extended. So where is the question of,
No, has the IA been disposed?
No, Lordship.
Then,
but 226(3) petition, after that, within a period of 14 years was heard.
hello.
So let it be on the 9th, Lordship,
28.
9th.
No, it will last line to Nelly, huh? It is the urgency ko tha to them. Not 9. No. At the 28th, you see, there are a lot of matters.
55.
Yes, list this, Mr. A. Ganguly submits that there is a connected petition being the WBC number 5382/2024. The same be also listed along with the same incident proceedings.
9th, Lordship.
9th.
Public.
Yes, what is this?
55.
Merit results. Petitioner is the elected chairman of the Departmental Ministerial Board, Lordship. 28/6/2024. 8 Ward Commissioner has brought a no confidence motion against the petitioner, Lordship.
Oh, I remember
Lordship. Lordship,
that on
kindly,
the day on which the petitioner was removed by another resolution dated on the same date, the respondent number 8 was selected as the chairman of the remand, that too without calling. Yes. Now what has happened? Set aside or not?
not Lordship.
You still.
Yes, Lordship.
Really? Who is appearing? Yes, you are appearing for whom?
The principal, the board knows.
How is it possible? How are you doing it? On the same day?
Lordship, subsequently, Lordship, it is right that on the same day, the decision was taken, Lordship.
How? Fellow,
Page number 55.
release this matter tomorrow at 2. Dispose it of. You can't do this. How can it, it categorically mentions that you can't have it on that day.
Subsequent developments are there.
We are not concerned. How can you have it on that day?
That was reviewed, Lordship,
You can, who reviews?
the board.
Oh my goodness. Where's the power of review? Where's the power of review in the municipal board?
Earlier.
Absolutely not. You can't review a order which is absolutely honest. Tomorrow at 2. We allow your requisition.
68.
Sixteen.
60.
Today we have filed it, Lord. Got the record.
Huh?
Today we have filed it, Lord.
We filed the affidavit today. Okay. This matter again on 25/11/2024.
In the affidavit, they have admitted the extension of the room. They have.
Ah,
They have-
in your favor?
Yes, yes. Only breadth has been mentioned, but length has not been mentioned.
We'll catch over. This matter on 25/11/2024. Taking into account that the respondent, taking into account that District Commissioner Borpeta had filed an affidavit today. Post of the registry shall bring on record the said affidavit. We'll have it on 27.
For orders, item 6.
Incomplete address.
Your Lordship, by an affidavit, I have brought on record the proper address, so I may be allowed to take steps.
Whose address?
Container number 3 and 4.
Huh?
3 and 4, contractor and the.
What remains? What has happened to your writ petition?
This petition has been disposed of.
What happened?
It has been allowed.
Writ petition allowed. Now what is wrong? Why you are doing all these things now?
Your Lordship, during the pendency of this writ petition, the stay order has been violated by the.
Understood. Now what has happened?
Presently, construction has been stopped.
Now it is stopped. The writ petition has been allowed. So what remains? Unnecessary, why you are doing this? And now those person is also not there, na?
Lordship, so far, petitioner number 1 is concerned. I have to take instruction from petition number 2.
For what? Withdrawal. You can't withdraw. I have to drop. I'm dropping it. What is that? Writ petition has been allowed by what, which order? This type of matter should not remain. So that I can give you more time in another matter.
If that order presented. That has been allowed in my presence.
So Leho, the instant application for contempt has been filed alleging willful and deliberate violation to the order dated 9/12/2014 passed in WPC number 6434/2014. Mr. And so the learned counsel appearing on behalf of the petitioner D. Mondal, the learned counsel appearing on behalf of the petitioner, submits that in the meantime, the writ petition being WPC number 6434/2014 have been allowed. Taking into account the above. So there is no acquisition now
No,
allowed, and thereby the apprehension of the forceful acquisition on the basis of which the writ petition was filed have been set to rest. Taking into account the above, nothing further remains to be adjudicated in the instant contempt proceedings for which the contempt proceeding stands dropped.
obliged.
57.
Yeah, please, Lordship. I shall be very sorry that on the due dates, I have missed the dates in my diary, your Lordship.
Why you are not taking steps?
Your Lordship, kindly allow me only 3 days time, I shall take the steps, your Lordship. On 12/6 and and 6/8, your
The petitioner, in spite of being directed by the laws of the court, have failed to take steps. Mr. M. Sharma submits that the steps would be taken within 7 days to list this matter after completion of service.
and your Lordship.
Yeah.
Yes,
Yes, my lord,
what is this? Why the matter has come up?
this is I pray for an interim order, interim protection, IA case.
কারণ এটা কি আছে? আইএ কি তখন আছে নি? What is the IA for?
IA for interim protection for not to take coercive action by the.
Which bank? Reserve Bank of India?
Yes,
PNB?
PNB.
PNB is Mr. S. Dutta. Who appears for PNB? Who is taking action? Has notice been issued? It will serve copies. You have to issue notice on this application. Have you served copies upon the income tax authorities?
No, income tax, I have not,
And you you have made a prayer for what?
so not to take coercive action. Regarding outstanding payment.
No, what is your prayer?
Where is that,
Huh?
not to take a coercive action against the enforcement of.
You are asking not to go action from whom? The enforcement directorate.
For the enforcement directorate,
Have you served copies upon the enforcement directorate here? The lawyer?
no,
Then how is it possible? No. You notice. I economic. Issue notice upon the opposite parties respondents herein. And you are asking against the enforcement directorate and you have not made them a party. See, you are an application for interim protection in the above mentioned case directing the assistant director, enforcement directorate, government of Iman, as well as the jurisdictional custom and income tax officer not to take coercive action with regard to the petitioner's import liability. And you have not made them party. Are you not required to make them a party?
They should the shoppers summon. Right.
Mr. Counsel, are you not required to make these people party? You want a direction, I issue the direction to whom? You are making the Reserve Bank a party,
Yeah.
General Manager Forex Exchange Reserve Bank a party, UBI, PNB your party, Manager PNB your party. Nobody. Who is the Enforcement Directorate? Where is the Income Tax Authorities?
PNB, that is at page 18, my lord.
Mr. Counsel, why you are asking against the Enforcement Directorate or the customs of the income tax? Your application is not maintainable in this manner. File it properly. Make these people a party if you want. Counsel appearing on behalf of the applicant submits that there being certain formal defects in not arraying the parties against whom relief has been sought for. He may be permitted to file appropriate application and will withdraw the instant application with the liberty to refile by removing those formal defects. Taking into account the above, the instant application stands closed on withdrawal. Liberty, however, is given to refile by removing those formal defects. Yes.
59 and 60.
Much of it.
Yes, what is this? Why the matter has come?
My affidavit is pending.
No steps for respond number 6. Strike out their name.
Take steps, my lord.
Mr. SD submits that he would take steps against, insofar as the respond number 6 is concerned. Good stuff. This, yeah, 7 days time in that regard is granted. This matter after completion of service upon the respond number 6.
61.
Yes, dismiss for default.
Filed for restoration of petition number 6881, which was dismissed on 2/4/2024. Your lordship will find at page number 16. Lordship, this matter was initially fixed for usual hearing in usual course on 8/1/2018. Your lordship will find the page order in page number 10.
That court is sitting, na?
Yes, sir.
Why didn't you appear?
Lordship, matter was fixed for usual course of hearing in the year 2018. Thereafter, it has been listed in part 2 in 2023. And on that day, Lordship, I could not appear.
It came in the top of the list.
Lordship, only for due to overlook the cost list, Lordship.
The part 2 concept has gone. There is no part 2 nowadays. Don't find any ground. Dismiss.
Lordship,
50,000. Upon you. You are responsible. Reach the matter before the appropriate bench.
Hello.
Yes. What is this?
Some corrections in the order.
What happened? None appears on behalf of the applicant. No, list this matter after warning. None appears in before.
Three and 64.
Well, we have filed this IA for seeking notification of an order passed by the Honorable Court on 2/3/2023. At page 82.
Which order?
Page 82.
Page?
Page 82 of the IA. Kindly come to the next page, 83. The relevant portion is the respondents are restrained from evicting the writ petitioners. The second last.
Yes,
Matlab, the paragraph 5 we have stated that matlab, the 864 bighas of government land that has been earmarked for a solar
this is an application for vacation modification.
modification of the order.
This matter on 27/11/2024 in the column of stay vacated.
So can it be on 29? Can it be on 29?
Okay, list this matter on 4th of December 2000 in the column of stay vacated.
70.
List the matter of the completion of service.
71.
List the matter of 2 weeks. 72.
22.
In compliance of the order dated 4/11, we have filed an affidavit on Monday.
Please the affidavit. Now what has happened? This is that 4 lakh one, no? 4 lakh something, isn't that? 5,21,000. Then
Now, Lordship, we have so caused the executive engineer because the
you have so caused him.
yes, Lordship, because he's saying that we do not have the document which they should not be saying. Lordship.
This court have duly taken note of the affidavit so filed by the filed on 18th of November 2024 by the respondent. Full stop. It has been mentioned that some action has been taken against the concerned chief executive engineer. Full stop. List this matter again on 11th of December 2024 for providing an update as regards the further steps being taken in that regard.
3.
Service complete.
Reply file, well, in respect of respond number 4 and 6, my lord.
Pleadings complete.
Pleadings complete.
Election of Assam Pharmacy Council, Constitution of Pharmacy Council. Any day,
Service complete.
Yes,
We have it for admission. Service being completed, let's admission on 6th of December. In the meantime, if the respondents would be at, the parties would be at liberty to exchange the pleadings.
Item 34 to 38.
Oh, you are early. What did early matter? Yes, what is that? Proposal number?
Well, it is progress further.
This is the financial sanction, and this is the ceiling. Ceiling was sent on 18th. It is only day before.
Mr. D. Gogoi, the learned counsel appearing on behalf of the EHE department submitted that pursuant to the orders passed by this court, that the ceiling proposal being proposal number P-PHE-0098 have been submitted. 98, comma, P-PHE-0099 P-PHE-0087 and 0087 have been placed before the finance budget section for the ceiling, for the ceiling. For the appropriate financial sections. Mr. P. Naik, the learned counsel appearing on behalf of the finance department have also been provided with the ceiling proposal, copies of the ceiling proposals by Mr. D. Gogoi. Mr. P. Naik shall take appropriate instructions in the matter. He submits that some time would be required in view of the fact that the said proposals were made only on 18/11/2024. List this matter for an update on 18/12/2024. This I won't keep it. You have it. Number it asylum, huh?